area of carrots and sticks. We do need financial incentives for seismic retrofitting and the flexibility to do upgrades in phases. This is the cost on when you put that on top of rehabilitation that often keeps historic buildings sitting there in a fallow state. You probably remember that we would be proposing a state historic rehab incentive, and Restore Oregon brought forth legislation in the last session that received the city's support. Thank you very much for that. Although we couldn't find funding for it there in the Capitol. And I'm hoping you will join with us in keeping the pressure on for that. That still needs to happen. And as proposed, and I assume would be similar to what would come forward in the future, it would be a 20% rebate for historic rehabilitation. And that's particularly important for the smaller historic buildings that don't attract deep-pocketed developers to do the work.
Peggy, I want to get you to wrap up because we're running out of time.
Sorry. I think some other ideas that we need to consider is an ordinance that prohibits demolition by neglect. There are a lot of cities that have that. I think that's an idea we should explore. I do appreciate the idea about a tax on demolition. We need to make sure that we do enforce meaningful demolition delay periods that allow conversations about alternatives to demolition. And we definitely need those design guidelines, both in the residential infill arena, in the Skidmore district, Japantown, Chinatown. That kind of clarity helps make it easier for these historic projects to happen and the compatible infill to happen. So we thank you very much for inviting our input in so many of the different commissions and task force that have been going on over the past year. And we look forward to contributing more good ideas to preserve our historic assets as we also build for the future.
Thank you. Please keep those coming.
Actually, Ms. Moretti, can I ask a question?
Yes.
On the term demolition epidemic, I'd like to get a sense of what you think is sort of like a normal and acceptable amount of demolition. I mean, you don't expect the average house to last for 1,000 years, so if 1/10% of all houses are coming down every year, that to me at least would seem kind of normal. You expect houses to last for more than 10 years, so if 10% of all houses are being torn down every year, then obviously that would be an epidemic. What do you think is like a normal level? What's a demolition disease, and what rises to an epidemic in terms of percentages of houses?
Well, we clearly have a very rapidly increased number of demolitions, and so many of those demolitions are on houses and structures that have a lot of good life left in them. It's one thing if it's something that's just, like you say, has run its course and it doesn't have much value left in it. And there are some of those. I mean, certainly not every one of these houses that's come down should have been kept, but there's an awful lot of very good, lots of good use left in it, places that are being demolished. And to me, that's what's out of whack here, out of balance.
But what's a lot? I mean, what percentage of the housing stock do you think of as a lot? Or does it not matter? I mean, if 10 good houses are being torn down, is that an epidemic, even though it's a small number?
When you see, well, I don't know what the right percentage should be. To me, I think there is something of a value judgment in that, but the acceleration that we have seen, I don't think is average at all. And I think it's probably tripled is what we've seen. I mean, every single day we receive demolition applications in our mail, 2 to 4 every single day. That seems like a lot. That does seem like a lot to me.
Yeah, I mean, one way to look at it, I mean, it's a fair question, Steve. If you believe that a well-constructed wood frame house can last 300 years, and since my parents-in-law live in a 250-year-old wood frame house in New Hampshire that looks like it's going to be around for at least another 100 years, then maybe 400 houses a year statistically is the right rate. But of course, we don't have any 250-year-old houses in Portland. So we're tearing down houses that are 100 years old and are at the first third of their useful life, even if you just look at that on a statistical basis. So we're at that replacement rate 200 years early.
Yeah. The average age, I believe, of the demolished house, if I'm not mistaken, is about circa 1920. So it's both historic. It's got some really good materials in it, and I would say in many of the cases it had a lot more life to it.
Brandon, welcome.
Mayor Hales, commissioners, I'm here today to talk about what it means to be a historic resource. But I wanted to start by saying that Portland is fortunate to have a Landmarks Commission as talented and as dedicated as we have. I work around the state with the 70-some communities that have landmarks commissions, and what we have here is a treasurer. The City of Portland recognizes 4 categories of historic resources: National Register properties, local landmark properties, conservation properties, and historic resource inventory properties. The inventory was adopted by the Landmarks Commission in 1984. It includes approximately 5,000 properties. Unfortunately, since 2002, properties on the historic resource inventory have been able to be demolished without any protection or any delay period as prescribed by the zoning code. This provision of the code, Title 33-445-510, subsection B, was inserted in 2002 as part of a larger package of amendments altering the zoning code. This provision allows owners of historic resource inventory properties, like the one on the screen we'll show in a second, to be removed on the same day that their owners request removal. While historic resource inventory properties are included in the zoning code as a type of historic resource and subject to a 120-day demolition delay, this code loophole allows those property owners to come off the inventory. Since 2002, over 170 properties have come off of the inventory in this way. Most of those properties are smaller single-family houses, commercial stores, the kinds of things that historic preservationists don't notice until after they're gone. On November 5th, 2 properties that you can see from the front door of City Hall were removed from the inventory with an expectation of demolition. Unfortunately, once they're off of the inventory, because of our state's unique owner consent law, there is no opportunity to designate the resources or protect them with the type of expertise that the Landmarks Commission can offer. More to the point, once a property is off of the inventory, it's no longer subject to some of the documentation and salvage requirements that would otherwise be expected for a demolition proposal for a property on the inventory. In our estimation, allowing properties to come off of the inventory without any notice, hearing, or delay cripples the ability of the historic preservation community to meaningfully engage with property owners and with the development community to find alternatives to demolition. The removal of the Ancient Order of United Workmen's Temple and the Lotus Cafe on November 5th represents maybe the most egregious use of this loophole since 2002. The memo in front of you describes how this commission can easily close the loophole in the short term while we consider how we would update the inventory in the long term. And I'll stop there.
So does state law not require us to take a property off if the owner asks?
So the state owner consent law requires, for local designations, the owner to provide their consent for that local designation.
To
But
put it
the
on.
law goes on to explain that any owner who refuses consent is required to wait 120 days before modifying or demolishing that structure.
That's to put it on, though. What's the rules for taking a designation off?
So that is an item that we've been engaging with at the state Supreme Court, and actually this commission has included the city attorney here in that discussion, because there is still a legal question as to which owners can request removal from historic designation. In the past, it was assumed that only that owner who had the designation imposed on them could request removal, though a case out of Lake Oswego broadened that interpretation to potentially any owner who can request removal. So that actually just a week ago yesterday was at oral arguments in state Supreme Court to determine that question of who can come off.
So I'll be interested from our city attorneys later to know, is there something in the interim while this court case is pending that we could do to protect those 2 resources that you've noted?
And I'll say one more thing.
120 delay, though, should still apply, even if they pull it.
That 120 days for an organization like ours, while it might not save every building, does have the opportunity to provide a feasibility study or to understand the true seismic risk of a building and the relative trade-offs that could be accomplished with a community dialogue. So even at a bare minimum, if the code allowed for that 120 days, we could right now be engaging in discussions rather than here reacting to something that we can't
So the
control.
proposed, you have on the back of your testimony a proposed council action. And you propose that we strike sub B of 33.445.510. Would that have the effect of then providing a 120-day clock before it can be taken off?
It would, and that would be, in our estimation, the right response to both state law and the remainder of the zoning code, which does specifically say historic resource inventory properties are subject to a 120-day delay.
Now and this not directly before us right now, but if the council was persuaded to do that, we could not apply it retroactively to any property that has been delisted, correct?
I wouldn't imagine so in a legislative action, but Carrie Richter will follow my testimony up and might have more insight.
Just guessing, we can't, that sounds like something we can't do, but we could certainly entertain whether we want to make this change going forward and perhaps even have a hearing on it.
That'd be great.
Please.
By the way, why, you said that it was part of a package that we adopted in 2002, and my memory isn't that good. Actually, I wasn't actually on the council then.
That's
so
okay.
I have, it's worse than I thought. Was this an issue in the package that was clearly framed for council consideration? Was this a considered action, or is this part of an omnibus action that did not get the attention you think it deserved?
That's a good question, and I probably have less reference because I had my learner's permit at the time, so it was a long time ago. But my
Rub it
understanding
in now, Brandon.
from the records from those deliberations is that there's no in the official records from the stakeholder advisory committee and the discussions around the broader package of code changes. I can't find any language explaining why that subsection was added, other than to assume it was a response to the 1995 owner consent law that maybe only read part of that law. But it's interesting because the rest of those code changes are full of track change notes from commission members and city staff.
And it certainly is contradictory. It's contradicting the clear intent there of of putting in the 120-day delay. Why would you have that if you could instantly remove it? So it doesn't make sense.
Thank you.
You've called this to our attention in a very useful way. Thank you.
Thank you.
You're welcome.
Good afternoon, Mayor Hales and Commission. My name is Carrie Richter. I am an attorney at the law firm Garvey Schubert Bear, but I was also the chair of the Portland Landmarks Commission and served an 8-year term. And I want to myself congratulate Chair Emmerich for leading the commission in a masterful way upon my retirement. So, and I am so grateful to them for all the work they have done and taking on the policy charges in a lot of ways that I think as a commission we were not able to do in terms of being involved proactively in the new comprehensive plan, the quadrant planning, and this unreinforced masonry work I think is wonderful. So that's sort of my first point. My second point is I was the attorney representing Restore Oregon and representing the city of Portland on the Carmen House case, the Lake Oswego case that has to do with the owner consent law. Oral argument did happen last week, and I think we are all encouraged that that is going to turn out to be something that the Supreme Court understands that the owner consent law was only intended to apply to the owner at the time the designation was imposed and was not intended to carry forward. We've identified about 1,700 designated resources in Portland that are at risk of delisting by subsequent owners if the Supreme Court rules the way the Court of Appeals does. Third point, I want to just follow up on the demolition code revision issue that Restore Oregon has raised. And I want to point out that there is ambiguity within your code already. Commissioner Fish pointed out the provision that Restore Oregon wants removed. There is another provision a little further down in the code, that 33.445.520A2, that says issuance of a demolition permit after demolition review, this is for HRI resources, requires a 120-day delay. And in the case of the Ancient Order United Workmen Temple and the Hotel Albion, both of those, design review advice has happened to take down these buildings already. City staff knew the intent was to demolish the buildings. If we know the intent is to demolish the buildings, it seems to me that the appropriate review standard would have been this one I just read to you that would have subjected this resource to a 120-day delay. It is not as though the city didn't know that these buildings were going to come down. And I think that that's a real problem, that first of all necessitates amending the code, and second of all being more rigorous until we get the code amended when these applications come in, because it is not as though these folks are just wanting to come off. Thank you.
Thank you very much, Carrie. Thank you all. Okay, let's take the next three folks, please.
Next are Kathy Galbraith, and she'll be coming with Denise McGriff and Mary Helen Kincaid.
Good afternoon. Why don't you go ahead and get started, Mel, while Kathy and Denise are getting ready.
Okay, last time I was here, Commissioner Novick had a great quote, and George Brett said, "Go Royals," and they went, and now they're world champions. So I hope I score a World Series win here. I wanted to comment that I am here as Mary Helen Kincaid citizen. And a common issue, though, I sit on DRAC, and a common issue that DRAC, the Demolition Task Force, council testimony, neighborhood meetings, and information shared with city council and their staff is that there are houses in neighborhoods that are significant. Not necessarily historic, but significant. And some have the potential to be saved, but neighborhoods don't have a capacity to deal with the process that's in place. There are currently no tools to do that, and the tools we've been trying to use are not adequate. Neighborhoods are frustrated. We don't have the right tools to identify what people believe are significant, and how do we get to that desired future outcome of saving those significant houses. My last testimony, I said I had a plan, and we have, and I've discovered a tool that it assists neighborhoods and saves some houses from demolitions. It identifies houses that are significant and possible targets for demolition because of their lot configuration, their historic nature, or just significance. It uses a variety of data resources, one of which is the HRI, and we all have heard and know that the HRI is in need of great revision. The Historic Landmarks Commission report mentions that the work of the Demolition Task Force and how it addressed the issues of demolition, notification, and appeals process, and urges for continuing funding to support the compliance. While compliance is good, it's not going to stop demolitions. 6 appeals have been filed, 3 were granted the extension, and no houses have been saved. A group of concerned neighborhood land use activists involved with those 6 appeal cases, and including Brandon from Restore Oregon, who headed the effort, has created a toolkit of best practices for filing an appeal and extending the delay period for a total of 95 days. To appeal at this stage when the developer has already invested a considerable amount of money and contracts are in place is not the best way to save a house. The appeal process frustrates everyone, and even the hearings officer. The HRI is currently the only reference point for neighborhoods to determine significance, and by all accounts, it is outdated, and some of those are not so good tools. I agree that the HRI needs to have the start over button hit, and I believe the project we are proposing would save houses, is ready to go now, and would enhance the work of any future efforts of the HRI. Quoting the Landmark Commission report, a revised historic resource inventory would bring the city's interest to maintaining neighborhood livability to the forefront and would allow neighborhoods to explore their historical identities through a grassroots and well-planned inventory effort. We are there now, we just need to help the neighborhoods in their efforts. We've presented this project to Paul Scarlett, Director of BDS, Commissioner Saltzman's staff, and we're scheduled to present it to the staff from the Mayor's office and Commissioner Novick's office, and Susan Anderson and Joe Zender of BPS. We think it would augment the work being proposed by the Historic Landmarks Commission for the new position of Historic Preservation Planner. But that project will focus solely on historic. And while this hearing is about the HLC and HRI, our project can enhance those efforts by having a broader look at neighborhood livability and significance. The project will give neighborhoods, developers, and landowners the tool to start the conversation before the demolition permit is filed. It'll be non-regulatory, and it won't create a fine, a tax, or a charge. It'll be preemptive and help preserve neighborhood character in those houses deemed significant. It's a positive approach to saving houses by laying groundwork for future work to preserve historic residential structures we don't even know about. This is an opportunity to do what Paul Hawkins says in his quote, "Good management is the art of making problems so interesting and their solutions so constructive that everyone wants to get to work and deal with them." You'll hear a little testimony a little later from Mike Molinaro, who created this project, but I just think it's an excellent opportunity.
Thank you. We look forward to hearing your proposal. That's great. Denise, welcome.
Welcome. Good afternoon. I'm Denise McGriff, and I have the privilege of representing the state of Oregon on the Board of Advisors for the National Trust for Historic Preservation. But today, I'm here representing the Advocacy Committee for the Bosco Milligan Foundation, and I won't go into a great deal of detail, but the committee strongly supports the recommendation that the Historic Landmarks Commission and Restore Oregon have recommended to you regarding removal of the zoning code section that allows property owners to remove their HRI designation. I'd like to briefly depart from that testimony and give you a little personal observation. Last year, I attended the Historic Preservation Program's McMath Awards, and you all know about George McMath and his history here with the city in starting our Historic Preservation Program. Leo G. Williams was the recipient of the award. During Leo's presentation and discussion about all the work he and George did together to start that program, I was disturbingly reminded of how far we have not gone in the city of Portland to do all the work that I think George envisioned, Leo envisioned, and our late friend Art DeMuro envisioned. I really urge you to seriously implement all of the recommendations that the Landmarks Commission has proposed to you, because they are the foundation of this city's program. And we have so much to be thankful for in terms of the resources of this city. As you recall, in 2005, the National Trust was hosted in the city of Portland. And when I go to conferences, which I just came back from DC, they're still talking about the Portland Conference, which is great because that says something real good about what we did. I really urge you to not only talk the talk about our preservation program here in the city of Portland, but to walk the walk and implement these changes. Thank you.
Thank you. Kathy, welcome.
Good afternoon. I'm Kathy Galbraith, and I'm the Executive Director of the Bosco Milligan Foundation, and we own and operate the Architectural Heritage Center at 701 Southeast Grand Avenue. It's the oldest building in the Grand Avenue East Portland Historic District, and we're well aware of all of the threatened developments in our immediate environment. In addition to commenting on support for the Historic Landmarks Commission's 7th annual report, I'm here to focus on the emergency that is happening, where our vintage buildings are disappearing, being deliberately erased at a rate never before seen in the city of Portland, probably since the Lewis and Clark Exposition. All of that time, we were building new buildings and not demolishing what was old. We, of course, support the recommendations and the comments of the Landmarks Commission's report about design guidelines for Skidmore Old Town and seismic upgrades for vintage and historic buildings. But the epidemic of demolitions that continues to rage through the city is unfortunately the conclusion that's reached by BDS in the Landmarks Commission's report is that the city is balancing the concerns of the various stakeholders. And we disagree with that, because only demolitions in low-density residential zones are subject to the review, and we receive all of those notices, so we know what the magnitude of those are. But we're also paying attention to all of the demolition applications. There are at least as many demolitions happening of buildings that are not in low-density residential zones, and we're losing a tremendous number of vintage and historic buildings without any delay or review. You've heard a lot of discussion about the status of Portland's historic resources inventory and all the flawed issues around its lack of formal evaluation and adoption when it was finished, and I don't need to go into that. But we have a process that's essentially voluntary, and for a city of the caliber of Portland to be the single city with this weak and ineffective process, it's really a national embarrassment when I deal with my colleagues around the country who just cannot believe that our program is as weak and ineffective as it is, given Portland's reputation on a number of other fronts. There's a particular concern I want to bring to your attention today, and that is in 2010, BPS engaged my organization to update our continuing Cornerstones African American Buildings History Documentation Project, which we started in 1993. It was to be used in the work on the North-Northeast Quadrant Plan to protect and identify African American historic resources, but nothing was done after we provided the update. We found that 10 of the original 1,284 standing buildings that we had identified had been demolished between 1998 and 2010. That was over a 12-year period. But more recently, we've been looking at all of the demolition applications and the impacts those are having on our Cornerstones inventory, and we've done a very preliminary review which shows that at least 12 of the African American historic resources have been demolished between 2010 and August of 2015, with a startling acceleration in 2015. And of course, none of these buildings are subject to any delay, and there's no protection from them. So we have our work cut out for us, and I know all of you have incredible tolerance to sit here and listen to us go on and on and on about our favorite subject, and this is one of thousands of issues that you're obligated to deal with, and you have tremendous tolerance. I try to come down here as little as possible to bother you about things, but Portland's beloved reputation, its character, its quality of life, its place that everybody wants to be is in large part based on what the city feels like. And the way that it feels like is based on what it looks like. And what it looks like is based in large part on its natural character and its building character. And we just can't afford to risk squandering that building character by not paying enough attention to the resources that my profession cares about, and I know you do too.
Kathy, first of all, we never tire of hearing from you. Second, I've lived in cities that committed egregious acts of civic vandalism, and they continually, even to this day, look back and regret that they either allowed historic structures to be demolished or demolished through neglect or whatever. One thing I will say, though, is that because we have so much coming at us, it does strike me that when we identify one or two or three discrete things that we're asked to do, it's more likely that we'll do it. So like earlier, we heard a particular statutory problem about the 120-day clock, and we have a proposed remedy. Well, we could tackle that very quickly and put something in place. And there's some other things here that seem very targeted. So my sense is that the more we identify a specific problem and outcome, and we're clear, the more likely that we'll be able to address it in an expeditious manner.
You're here. Thank you very much. Thank you all. I'm going to take a few more folks that want to testify on this. I know there are a lot of people here for the next item, so bear with us. I think we have 5 or 6 more people signed up to speak. Let's hear them, and then we'll move on.
I hope you all get a good night's sleep for tomorrow.
Yeah, yes, right. We have a comp plan hearing tomorrow. Speaking of
William
managing change.
Willingham, Mike Molinaro, and Allison Clare.
Welcome. Good afternoon.
Hi, my name is Bill Willingham. I'm a consulting historian, and I'd like to speak to you today about the need to update the historic resources inventory. And I bring to that some special knowledge in that I was the historian, along with Al Staley, the architect, who did the research that created the very first inventory back in the early 80s. What you all know, but we probably need to think about it again, is the fact that Portland is blessed with a built environment that reflects 150 years of virtually every architectural style. It has buildings that reflect those. And they're important not only for architecture, but also for their association with culture, with commerce, with ethnic diversity. So what is really key is that we build our knowledge base so that we know what out of that 150 years worth of built environment we need to preserve. And so the inventory is only the first step of that. Then you have to evaluate those properties according to appropriate standards so that you can rank or determine significance, so that when you come to these issues of demolition that present a building in a microcosm, that you know where it fits in that larger universe so that you can make rational decisions. So I just encourage that you, as quickly as possible, find the resources to update that inventory, because as others have pointed out, City of Portland has grown and we've marched 30 years ahead so that we're now able to evaluate buildings from the 50s and 60s according to the 50-year standard as the cutoff date. And if we don't get that inventory updated, then we can't appropriately deal with these new resources that need to be affected. So I won't take any more time to repeat what others have said, but I think the focus needs to be on updating that inventory. And I'd like to see my work carried on.
Thank you very much. We would too. Good afternoon, Mike.
Good afternoon. I'm Michael Molinaro, and I want to thank Mary Helen for her introduction and referring to me as a tool. I think it's the first time that's ever happened.
She didn't mean it that way.
Yeah. One of the reasons Jan and I moved to Portland 3 years ago was my interest in historic architecture. Having renovated and restored over 500,000 square feet of local and national landmark buildings, I was attracted not only to the major landmarks we all know, but to the historic character of Portland's neighborhoods. Neighborhoods here are named after a mountain, a creek, or even a waterfowl. But we moved into one named for an idea, Sunnyside. I soon discovered a gap in the recognition of historic Sunnyside structures, since the HRI was completed in the 80s. I could not find an updated accounting of these 133 properties, so I set off to examine them myself. In addition, by looking at every single residential property, I documented not only the HRIs, but over 300 additional residences that I feel could be considered as an asset to that historic resource. Dropped into a database, I can now search and group them using over 50 different categories. In my opinion, these are the properties that make up the residential fabric of Sunnyside. Many of these are also the properties that are most vulnerable to demolition. No tax, fee, or appeal process can ever bring them back once they are gone. And so, in addition to my own historical survey, I have added to this database underlying lot line information. Now, by combining the two and with current data on market values, I can predict which of these properties is most likely to be demolished. This study, called Inventory of Significant Residential Properties, has been presented to city staff with 2 more presentations scheduled. If our pilot project is funded, it will be expanded to 4 other neighborhoods and can be utilized by all parties, owners, neighborhood associations, and developers, to potentially chart a course other than demolition and help maintain the affordability of housing. Thank you.
Thank you. Good afternoon.
Good afternoon, Mayor, Council. My name is Allison Clare. I'm a small clothing maker in town, and I'm also an apparel consultant. I'm a native Oregonian that lived in Portland for the last 15 years, and I'm really here on behalf of the Ancient Order of the United Workmen Temple. It's my favorite building in all of Portland. I grew up in Newburgh, and I used to beg someone's mom to drive us to Sherwood to ride the 12 bus for over an hour to come walk around the city in my teens. It's near and dear to me, and I'd always come and visit it when I was walking, which is kind of silly. But I was crushed when I saw that this happened with the Hotel Albion and this building potentially slated for demolition. It may be the straw that breaks my camel's back for staying in the city and keeping my businesses here. The character of the city is what draws me, and it draws people, and everyone that comes here loves it. So I'm just here on sort of a plea to keep these extremely historic buildings. It's beautiful and breathtaking, and I was almost in tears when I saw the plans for razzing it. They don't actually match the public notice of public hearing that's currently posted on the building, which shows the current structure with the building around it, and the plans have been updated. So just here to voice my concern, and thank you for your time.
Thank you. Thank you very much. Thank you all. Okay.
The last 3 who signed up are Teresa Kennedy Dupay, Dawn Dupay, and Sarah Stevenson.
Come on up.
My husband's not going to speak today.
Okay. Welcome.
Hi.
You can go ahead.
My name is Teresa Kennedy Dupay, and I am a local writer here in Portland. I'm currently publishing 2 books, one of which is a crime history book on early crime, police corruption, organized crime here in Portland. And I am co-authoring that book with writer J.D. Chandler. And it's a history book, and it's my love of history that brings me here today. Basically, I'm just a regular Portlander. I was born and raised here. I've lived here my whole life. And I have 2 favorite buildings in downtown Portland, the Lotus Hotel, formerly the Albion Hotel, and also the Ancient Order of the Workman Temple, Ancient Order of the United Workman Temple. About 2 years ago, I was fortunate enough to do a tour through the upper portion of the Lotus Hotel. I took over 100 photographs. I did a 5-minute video. I then wrote about an 8-page paper that I was going to submit to some local places in town, and I could never get my head around how to do that. Basically, the paper details the significance of the Lotus Hotel, the 1978 murder that happened in the bar of the Lotus Hotel, the ghosts that live in the basement and the upper portion of the Lotus Hotel, and all the history that goes with it. It was a wonderful experience, and as a writer, I benefited greatly because I learned about the history of Portland in a way that I hadn't really known before. I always wondered about the possibility that the Lotus might be demolished, and it's very distressing to me because the appeal of Portland, Oregon is so tied to our architectural history, and the character of downtown Portland is suffering with these consistent demolitions of old buildings. And I want to state that it's not impossible to restore these old buildings. The Cornelius suffered a catastrophic fire in 1988. It's being restored. The Harlow Block 82 on Northwest Gleason Street is being restored. There's no reason why the Lotus Hotel cannot also be restored. But I also just want to state, much like the woman who spoke before, I was baffled when I saw that the Ancient Order of the United Workman Temple was designated for demolition. I'm shocked. I'm horrified. I'm outraged that this could even be considered. It is so priceless a building. We have to do what we can to save the Ancient Order of the United Workman Temple and the Lotus Hotel. And that's my statement.
Well, I have one more nugget of information for your history, which I think I should disclose. And now that Commissioner Novick is in charge of the Transportation Bureau, he knows that the Lotus has been the after-hours hangout for transportation for many years.
Yes.
And I can now reveal that the wonderfully named city engineer at the time, Vic Rhodes, and I drew the street plan for what we now call the South Waterfront on a bar napkin at the Lotus one night. So unfortunately, we didn't keep the bar napkin, but we do have the street plan.
The Lotus Hotel is a very popular place. The business is booming, yeah.
Thank you very much. Good afternoon.
Hi, good afternoon. I'm Sarah Stevenson, and I'm here today as co-chair of the Old Town Chinatown Community Association's Land Use and Design Review Committee. Primarily, well, first to thank the members of the Landmarks Commission for their work on behalf of our city, and also to testify in support of their 2016 priorities and goals, specifically the development of historic design guidelines. I'd like to speak about two districts that sit within Old Town Chinatown, the Skidmore Old Town Historic District and New Chinatown Japantown Historic District. As you've heard, the Skidmore guidelines need to be updated. That is in process. It sounds like they're done and they're going to get in front of you very soon. We'd just like to thank planning and landmarks for that work and encourage you to approve them as soon as you can. New Chinatown, Japantown is a little different. We've never had design guidelines in that historic district. But with the increased focus on revitalization there, the district is facing development pressures and desperately needs those design guidelines. They're important not only to preserve our historic fabric, but also to give developers certainty about what they can do in the neighborhood and how they should proceed. We understand that PDC has allocated funds so planning can hire a consultant to expedite the process. We thank the city for listening to our earlier requests and taking steps to move these guidelines forward. We urge all parties involved to continue to prioritize their development, as we'd very much like to see guidelines for New Chinatown, Japantown in place by the end of 2016. We think 2017 is a little bit late. Preserving physical buildings, ensuring their compatibility with new development, and preserving the aesthetics of our historic districts is important work. Sometimes people ask why. It's just an old building. Sometimes it's not even a very pretty old building. But these physical spaces preserve a place for us to tell stories about the people who built our communities. Sometimes the stories are inspiring, sometimes they are ugly. But it's important for us to know and remember our own history so that we can continue creating the community that we want Portland to be. Thank you.
Thank you very much. Thank you all. Okay, Commissioner Salzman, I think a motion may be in order.
I would move to accept the report.
Second.
Further discussion? Let's take a roll call vote on that, please.
Novick?
I'm continually amazed at the dedication and hard work of the members of our volunteer commissions, and I thank you very, very much for your work. Aye.
Fritz?
Second that, and particularly thank Chair Brian Emmerich and Harris Matarazzo, who are both term limited out after 8 years of dedicated service. I want to echo Commissioner Fish's kudos for your handling of the Mount Tabor Reservoir and also the Washington Park Reservoir historic reviews. And it's a fascinating commission. You get to look at all kinds of different issues. I look forward, I smiled when somebody said that the Skidmore design guidelines will be coming to council soon. I've been hearing that every year for the last 7. So I'm really looking forward, Mayor, to you bringing it home right after the new year, and that'll be great. And also I'm very interested in New Chinatown, Japantown design guidelines. I'm shocked about the 2 buildings that are slated for demolition, and just horrified to think that they could be replaced by some out-of-the-box hotel that some out-of-town developer thinks is in keeping with our city. When you look around downtown Portland, there are so many beautiful buildings that make me proud to be a Portlander and just contribute to the character of our city in a way that a standard box hotel is not going to. So, Mayor, I hope that you'll be able to intervene in that. I need to tell my own Lotus hotel story, or at least the restaurant story. I go there at least once a month whenever I want to have a private conversation. The acoustics in that beautiful wood bar are such that if you go at noon, it's very noisy. You can perfectly hear your companion talking. Even if you try, you can't eavesdrop on the next table. So it's the perfect place to go and have a secret conversation right in the public eye. Try it sometime. It's really quite fun.
Now we know.
So thank you very much for the report and for all the work that you do. Aye.
The reporter's here, so you probably had your cover blown.
They still won't be able to go. They can you try it. It's not possible.
Fish.
Yes, thanks very much for this report. Each year, when we get this presentation, I find it inspiring and sobering. There's a number of things on your action list which I think we should prioritize, quite frankly. One is taking a quick look at Title 33 and seeing if we can make a discrete change, and I think that's something we'll be discussing with Dan and BDS. The second is having a full-time preservation person in the Bureau, a senior person, a senior planning position. This is a tough budget cycle. The mayor has given guidance that every bureau's got to at least identify a 5% cut package as a fallback. But I'd like to know more about the staffing around this, and it seems like a reasonable request. I too am looking forward to the Skidmore Old Town stuff coming back to us. The last time we took it up was Commissioner Fritz 4 years ago or something. It stalled on some controversial issues, but it needs to come back. And as to the general sentiment about the kind of soul of our city as reflected in historic structures, I could not agree more. And in fact, cities that have been farsighted about this have protected buildings and districts, and they've turned out to be high rent areas also, as people choose to live in areas that have historical roots and soul. So thank you for your good work. I'm pleased to vote aye.
Councilman?
Thank you, commission members, for your hard work, and past and present members as well. And I also want to acknowledge the role of staff, Tim Herron, and who staffs this commission well. And I think the testimony, as well as the commission members, have raised some good issues that we need to take a close look at, like this 120-day, lifting of the 120-day delay. That's something I will, as Commissioner Fish just indicated, take a look at and see if we can't bring something back to remedy that. So thank you very much. Aye.
Mills.
Well, some of you who are maybe here today and not here often may not know this, but we get these reports every year from both the Design Commission and the Landmarks Commission. And they're an excellent way for us to check in on what's working, and you've shown us some things that are, like how much better the Block 8L development was after your review than it started out before. So it's good to hear about what's working. But frankly, I don't think there's ever been a report at a time more important than right now that calls out what's not working. And you have really given us a call to action just in time to save some buildings that are otherwise going to be lost. And I really appreciate, as has been said by other members of the council, the clarity of both your call to action, and you've given us some very specific ways we can make it better. So you've certainly got my commitment. I think you've heard others here on the council as well that are committed to moving swiftly to make improvements that will avoid the losses that you have flagged. And we really don't have an excuse not to act if you've given us this much clarity, and we all can look around and see the rate of change that's underway. So we have a short time, both in the work we begin tomorrow afternoon in our first public hearing on the comprehensive plan, and in the specific issues you've called out here today. We have a little bit of time to keep Portland when we're forecast to accommodate 250,000 more people and 140,000 more jobs over the next 20 years. It's really important work. Thank you very much for what you brought us here today, and we look forward to having you back in the council chambers very soon for changes in our code. Aye. Thank you all very much. Okay, let's move on to our second item this afternoon, which is item 1208.
Add code removing barriers to employment to establish procedures for the use of criminal history information by employers within the city.
Thank you. Well, let me set this discussion up, and then we have some invited testimony and staff presentations on this proposal this afternoon. The best way to break the cycle of imprisonment is a job. We hear that again and again from people that do this work, from people who've been in the criminal justice system. In fact, the City Club heard it last week when Arthur Davis so poignantly talked about how his future was determined by his father's gang involvement and his own choices. And then right there at the City Club pointed out that he could use a job. We hear that story way too often. And in fact, we formed this amazing effort in Portland, along with other cities around the country, called the Black Male Achievement Initiative, and there are people in this room who work on that wonderful effort. And I got to know a couple of young men who visited with us as we did the work, Stephen Fowler and Robert White, both of whom, at the time I met them, were both in the criminal justice system, serving time in an Oregon prison. Robert has since been released and is doing well. Stephen is still in the system. And if you have ever had the chance to be inspired by a young person, I can tell you what that was like, because I was so inspired by them, and I wanted to hire both of these young men on the spot, but I know how difficult it will be for them to get through the interview process and get a job, and that's why we're here. Meanwhile, I'm the police commissioner, and we're having the worst year ever for gang violence. We've had 171 gang violence incidents in our city. We've had 163 shootings, 65 people hit, nearly 1,000 shell casings recovered, and 12 people killed in this terrible wave of gang violence. Now, some of those people that have been perpetrators of that violence are going to go into the system. Some of them are going to make amends and change their lives, and when they come out of prison, the best thing that can happen is for them to get a job. And so that's what this ordinance is about. It is both an economic issue, a public safety issue, and a racial justice issue. It's the best way for us to make sure as a community that we give people a chance and that we get great employees considered when they're out looking for work. What we're proposing here is an intentional and persistent breaking down of barriers. It's very consistent with what we've done in other ways to do that. The original policy proposal went through both work groups and then also through my mayor's business roundtable. They've made some improvements in the proposal that you'll hear about today. Those include having the State Bureau of Labor and Industries rather than the city serve as the enforcement entity, provide some tuning for particular situations like early background checks in public safety related businesses and for staffing companies. So, and a clear understanding that there are situations where out of business necessity, an employer needs to know this information early. But remember, what we're changing here is when the question is asked. That's all we're changing. It's when the question is asked in the employment process. It used to be that we could inquire as employers about someone's religion or their sexual orientation. No longer legal. It's still going to be legal in Portland to inquire about someone's criminal history, but there's a right time to do that and there's a wrong time to do that, and that's what this ordinance is about. So I want to ask City Attorney Judy Prosper to come up and walk us through the code changes between, again, the proposal that was in front of the council earlier this year and the one that's here today. Josh Alpert and Rachel Wiggins on my staff have worked hard on this, and they're available as well. And then we have some invited testimony. Judy, welcome.
Thank you, Mayor Hales. Good afternoon, Mayor and Commissioners. I am Judy Prosper, a Deputy City Attorney who helped your office draft the code changes. So the first thing I'd like to say is to acknowledge that the state earlier this year passed a version of Ban the Box, HB 3025. It was passed on June 26th. Signed by the governor on June 26th. I'm going to review some of the code changes that, as you mentioned, Mayor, and just highlight the differences. So I'm not going to go verbatim through the whole proposed code change. I'll bring your attention to 23-10-030, which talks precisely about the timing that you mentioned, making it an unlawful, I'm sorry, 23.10.030.
30.
Okay.
And I believe before you, you have a comparison that I may have distributed earlier. It's a, it says comparison between Ban the Box, state law and proposed code changes.
She's handing us that now.
Okay,
This thing?
yes, sir.
Thank you.
So again, I'm at 23-10-030, and the code proposes it is an unlawful practice for an employer to exclude an applicant from consideration solely because of the applicant's criminal history. B talks about the timing, that should happen after a conditional offer of employment. And D talks about the test in making a determination of whether an applicant's criminal history is job-related for the position in question and consistent with business necessity. An employer must conduct an individualized assessment of the nature and gravity of the offense, the time that has elapsed since the criminal offense took place, and the nature of the employment held or sought. Again, as you mentioned, Mayor Hales, E talks about that this is not, again, something that prevents employers from checking criminal history. It merely delays the time when they can do so. Things that cannot be considered that are mentioned in Section E: an arrest not leading to a conviction, convictions that have been judicially voided or expunged, and charges that have been resolved through the completion of a diversion or deferral of judgment program. I'm going to move down to Section 23-10-040, exceptions. This chapter would not apply where federal, state, or local law require the consideration of an applicant's criminal history to law enforcement, employees in the criminal justice system, and volunteer employees. B is, there's another handout that you may or may not have received yet, and it is what's colloquially known as the matrix. I'll talk a little bit about that, but if maybe Rachel can get that up to you so that we, here's mine. So 23.10.040 exceptions. Part B, for the following positions, an employer may consider an applicant's criminal history at any point in the hiring process and may use the city criminal history matrix provided by the administrative rule to screen applicants, but must nonetheless comply with all other requirements of this chapter. An individualized assessment shall be required for any conviction not contained in the criminal matrix. So again, it speaks to the administrative rules which have yet to be drafted. And what's before you now is what the state uses, the Department of Human Services, for employees that will be coming into contact with older folks and people with disabilities or developmental disabilities. And what it is a chart of convictions that will allow an employer at the Department of Human Services who's dealing with this population to either have a 5-year ban, a 10-year ban, or a permanent ban. So as it says, and the city has, of course, yet to adopt this, it will most likely, if the ordinance is adopted, look like this. And I'm just going to set an example because this is another question that has come up often, so maybe I'll head it off a little bit. The non-underlined ones are your most egregious crimes: aggravated murder, it goes through rape, sexual abuse, crimes against children, etc. The 10-year crime ban are drug crimes. So those are indicated, actually not indicated on this list. So any selling of drugs would be a 10-year bar. So the underlying ones on this list would be 5-year bars. And that includes public indecency, invasion of personal privacy, and computer crime, if charged as a felony. So I can go back to that if you have questions, but I'm going to continue down the highlights of the ordinance.
You know,
Sir?
I have to confess, I'm still trying to figure out how this list of crimes you just handed us, the DHS uses,
Yes.
where does that fit into what we're talking about right now? I don't get it.
Okay. So we're at the exceptions. We're at .040, exceptions to what was stated earlier, which is that the inquiry into a criminal conviction has to come at the conditional offer phase. What this would be proposing is an exception to that for the crimes listed on that matrix. So the ones that are not underlined, sorry.
I mean, how would you know unless somebody voluntarily discloses to you?
It's related to certain positions.
Exactly,
Related
thank you.
to-
It's related to certain positions, as Commissioner Fish said, that have to do with vulnerable populations. If you continue to look,
So it's all
if
those
you look at
under sub B
one,
there.
if the subsection's under B,
Yeah.
positions involving direct access to or provision of services to children, the elderly, persons with disabilities, persons with mental illness, or individuals with alcohol or drug dependence or substance abuse disorders. Positions that have been determined by administrative rules to present heightened public safety concerns or business necessity, and positions designated by the employer as part of a federal, state, or local government program designed to encourage the employment of those with criminal histories. So if you're soliciting employees for jobs that fit in any of these categories, you would be able to use the matrix ahead of time, which means you would be able to ask before the conditional offer phase whether a person has a criminal history and match that criminal history up against the matrix.
Okay.
Is that clearer?
Yeah, that's clear.
Judy, I think it would be helpful between now and next week if you gave us some illustrative examples of positions covered by these categories. So I think we can all sort of pick the poster child for each of these, but it'd be nice to have some additional examples of what's covered by 1, 2, and 3 categorically.
We'll do so.
What we're saying is we're trying to create, you're proposing an exception that's clear enough that the person hiring for that position knows that they have more latitude. And it's because it's a sensitive job involving public safety or a vulnerable population or whatever. And we're making a judgment that the rules don't apply in the same way to those positions. And by administrative rule, we'll flush that out. But to the extent these are taken from other code and are sort of meant to be shorthand for
Childcare providers.
A child care provider, domestic violence shelter, or whatever it is, I think it'd be helpful for us to see those.
We'll do, sir.
All right. Other particular points you want to raise, Judy, or questions?
About the exceptions, okay, I'm just going to move down to 23.060, enforcement. The last time we proposed some code changes, we had proposed a perhaps enforcement by the city attorney's office, and that is a change that's made, and the enforcement is proposed to be with the Bureau of Labor and Industries, and that is in line with what's happening, or what will happen with the state law.
So Judy, the state law is very clear that enforcement is to be done by Bureau of Labor and Industries. Why have we chosen the word may? City may contract. Why doesn't it say shall?
Well, maybe I can help with that. We can't force the Bureau of Labor and Industries to do anything. So they would have to be willing to do it, and then we would be able to negotiate a contract with them.
And they've indicated that they are.
My understanding is that,
Yeah.
in fact, they are willing to do it. Our concern at the beginning was whether they would be willing to do it or not.
So that's why you use the conditional may, not
Correct.
the directive shall, but it's still our intent to have Foley do the administrative enforcement.
It is, sir.
And they've indicated that they're prepared to do that.
Yeah.
Can we say
That's a-
the
that's a-
city's intent is to contract with Foley rather than the city may contract with? Given this discussion we just had?
Sure.
Okay.
Yeah, I mean, I
The
think
city's
it's,
intent
yeah, it's
is
very.
to contract with the Bureau of Labor and Industries.
This was a big discussion
Yeah.
previously about whether we were going to create our own enforcement wing of the city attorney's office.
Right.
Or access the established professional services of the Bureau of Labor and Industries. I think we've all been persuaded Boley's the better way to go.
I understand that the mayor has a proposed amendment that will direct us to negotiate with Boley, and I think
Yeah,
that will
okay.
capture your intent.
I'll run through those amendments in a minute, but yeah.
So Judy, since we're talking about enforcement, will you also, as you walk us through the enforcement section, would you explain how it dovetails with the 23.10.100 on application? Because the last sentence says that enforcement shall commence July 1, 2016. I just want to make sure I understand how those two fit together.
Can you point me to where you were, 23.10
100?
100?
Last paragraph.
And the last sentence says enforcement of this chapter under subsections blah, 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 shall commence July 1, 2016. So I want to make sure I understand enforcement and then the trigger date.
I'm going to confess that my copy has a line there for the date, so thank you for letting me know that it's intended to be July 1st, 2016.
Well,
So I think the intention with putting that date in is that between, if the time the ordinance and code changes were to be passed by council, the city attorney would commence negotiations with Boley to contract for them to do the enforcement. And that is contemplated to be
Again,
done by
I've
July
got some
1st.
amendment language that might clear this up when we get to that, so.
Okay.
So maybe I should go ahead and put those amendments before the council now, so that they just have that, we have these here before we even call up the invited testimony when we do that.
That sounds, do you want me to finish?
Sure, I'm sorry, go ahead.
Okay.
I think I've got all the amendments, so.
I think I was
Sorry, go ahead.
finished. I was waiting.
No, go ahead. I'm
No,
sorry.
I am done. That's the
Handing
enforcement mechanisms through Boley, and an amendment to that from Commissioner Salzman, saying that it is the city's intent to contract with Boley
Mayor,
to
let's-
enforce the provision.
Let's take your amendment, so
Yeah.
it's all on the table, and then we can take, I think that we have some more questions just to make sure we understand the.
Right, okay, so Rachel, I believe, has got copies of the amendments maybe in front of everyone, and I'm not sure I have them in the same order that everyone else does, but one is a scrivener's error to 23.10.060 enforcement that merely is a numerical change from 8 to 6 under sub B.
Second?
So there's that one.
Wait a second, I'm trying
That's
to
the-
find it.
that's
Oh,
the
Scrivener's
easy-
error, the
yeah.
one that's labeled there?
Scrivener's error is the
Okay.
first one. Then there's an amendment to the criminal history in employment decisions section that adds the words orally or. So what the effect of this is, it says, if after consideration of an applicant's criminal history, an employer rescinds the conditional offer of employment, the employer shall notify the applicant orally or in writing of its decision.
So Mayor, I'm going to second this, but I oppose this amendment for reasons I'll explain.
Okay, and I might need other staff up with Judy to walk through these amendments as we deal with them. So that one's second. Then we have this one about Boley, that Directive C is amended to read as follows. The city may contract with the Oregon Bureau of Labor and Industries, Boley, for enforcement of City Code Chapter 2310. The city attorney is directed to negotiate an intergovernmental agreement with Boley for enforcement of Chapter 2310 and to return to council for authorization of such agreement upon completion of the negotiations. So
Mayor, I don't know, where does this fit?
that is a revision of Directive C.
With the ordinance.
under
So the first few pages, sorry to interrupt you, just wanted to.
I'm not sure where it fits.
In the ordinance at the now, after, now, therefore. So it's the third page of the ordinance.
But I'm looking at the proposed code, so.
So before that
Yeah.
is the ordinance. And the third page of the ordinance after number 13 says, now therefore the council directs. And what the mayor is attempting to amend is C.
So again, the effect of it is that requiring the city attorney to prepare an intergovernmental agreement, bring it back to council for approval that does indeed have Boley conducting the enforcement.
And then what's the, if we make that change, which I support, Mayor, enforcement of the chapter would start when?
Right now, within the language, we have it July 1, 2016.
Okay, so there's a phase-in period of public education, of blah, 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 but that's when the hammer comes down in terms of penalty, the damages and penalties that Boley can enforce.
That is my understanding, yes.
Right. Yeah, okay, so is there a second to that?
Second that.
Okay, then,
D.
what am I missing, Rachel?
The final one is adding a directive D
Oh, yeah,
that
there
the
we go.
city attorney provides council with a one-year report on claims.
Okay, so then this is a new directive, right? Correct. That says the council directs D that the city attorney provide council with a one-year report on claims by individuals or action by the attorney general for both the state and the city.
Second.
Okay,
Mayor,
Does the
why is it the
Attorney
Attorney
General-
General?
Yeah, it's just,
why the attorney general?
doesn't the labor commissioner do it?
Yeah, the Attorney General will be enforcing the state statute on behalf of Boley. And then, I don't know if
Well, there's
Right,
three,
always, the attorney
There
general
are two
always
ways.
enforces state agency.
No, I know, but the data that I think we want is data of claims filed with Boley. So that tells us statistically how many people are filing claims, because some of those claims are determined administratively without the necessity of the AG taking action. So I think what we mean is claims filed with Boley, enforcement action taken by the Attorney General. And then I think, Mayor, since the state law contemplates setting up an oversight body, we ought to have something in here about at least engaging the oversight body that the governor is establishing to get whatever data they have for part of our report.
And that's an oversight body at Boley?
No, there's a provision in the state law that sets up a group that has oversight of the law, and their job is to collect data and monitor compliance. It's made up of legislators, I believe.
Can I correct one thing you said, Commissioner Fish? Claims filed by Boley, enforcement taken by,
Filed with Boley.
with Boley, thank you, sorry, with Boley, I wrote with. Enforcement taken by the commissioner of Boley. The AG may bring an action, stand as but the enforcement is taken by the commissioner of Boley,
It would
not
be-
by the AG.
The Attorney General may have some.
But the attorney general can bring a claim as well.
Yeah, so I think the intent of the mayor's amendment is that there be a report with all the available data on how this is working.
Right.
And
Well,
my
it's state
I'm not
law,
an expert
right.
on this, and state law hasn't kicked in yet, but I'm guessing it's claims with Boley, enforcement actions taken by Boley, and any actions taken by the state attorney general.
Is that right?
Correct.
Okay.
Very succinct, Josh.
Okay, and then I believe we have one more amendment, which was yours, Commissioner Novick, is that right?
That's right.
Okay.
It would be an amendment to 23.10.030, use of criminal history and employment decisions. And there would be amendment to paragraph 3, which says that charges that have been, okay, this again is a list of things that an employer shall not consider, such as an arrest not leading to a conviction, convictions that have been judicially voided or expunged, and item 3 is charges that have been resolved through the completion of diversion or deferral of judgment program, and the original draft ended there. I want to add the language, for offenses not involving physical harm or attempted physical harm to a person. I actually don't know if there are any such things as diversion or deferral programs for crimes involving physical or attempted physical harm, but just in case there should be or might be in the future, I think it's worth adding that
I think
caveat.
it's legitimate. I think assault charges are sometimes resolved through diversion, so somebody can clarify that for me, but I think that's true. Okay, so before we move on to questions, any other amendments to put on the table? So all those
I have
amendments
a-
have been
yeah.
moved. I'll second Commissioner Novick's amendment, so. Yes. please.
Well, I have some questions, and they may lead to an amendment, so.
Okay.
But I'll wait
Sure,
till.
well, we got the team here. Do you want to
Presentation.
wait till after we take testimony, or?
Well, I have questions on the amendments.
Okay.
So let me start with that. And
I'd rather-
I have some mixed feelings about the mayor's amendment inserting in 2310.030 the option of notifying the applicant orally or in writing. And let me just explain the concern that I have. we're creating a new system that for some employers, and I know we're proposing to exempt employers of less than 6, but for some employers is going to require some time to get it right, understand the nuance. And because it's a pretty sensitive thing we're regulating, there's going to be, at least, it seems to me as someone who used to bring these kinds of cases, a ripe opportunity for people to misunderstand each other. There's going to be plenty of opportunity for people to have different impressions of how the interaction went and what happened. What that means is that there's a likelihood that if these things get to an enforcement phase, you have a lot of the he said, she said, I think this happened, in which case those cases end up in the civil rights context being very, very unsatisfactory, because the burden of proof is substantial evidence. And if there's a contest between people's recollections or what they think happened and whatever, typically that case doesn't get to a finding. The virtue, and I'm torn on this, because I understand, I'm guessing the mayor doesn't want to make this so formal and bureaucratic that it's too prescribed. But I will just raise a caution flag. The virtue of something in writing is it controls for all purposes going forward. It's a statement, and it has to follow a certain form, and that document cannot be challenged on an enforcement action. It either complies or it doesn't. The challenge of allowing an exception for oral communication is that one or both of the parties could have a completely different understanding of what happened, in which case you're asking an administrative body to reconcile that. And I would tell you, historically, that works to the disadvantage of the complainant, because it's a contest. Now, and again, I think the point you're making, I believe in making this, and it may be that we want to adopt your approach and then test it.
Right.
But he said, she said usually doesn't end up very well for a complaining party. Something in writing does tend to be more solid evidence, and I'm torn on this one.
Yeah, we might get testimony on this point, because this came out of the Business Roundtable discussion, and I think it is an effort on our part to try to make this more practicable for employers. But if
Well, in that case, I'm torn. But
Yeah,
the
I am
other
too. I hear you.
question I wanted to ask our panel is, there's still one piece of this process which we're not addressing, which for many prospective employees is fatal to their process, which is the gap in their resume. And the reality is that for most people who've done time, there is a gap in their resume that at the front end of the process, an employer is going to take notice of. And to my knowledge, there's virtually no way to address that. But let's be clear, the resume comes in with a cover letter. The last 10 or 15 years has no employment history. We can prescribe that you can't ask certain questions, but how likely is that person going to get to a conditional offer? And worse, because I'm not sure we can regulate that, are we, and this is the worst case scenario, are we encouraging a certain kind of profiling at the front end, where that combined with something else is used to just take someone out of the pipeline so that the person doesn't get to the conditional offer, because the enforcement system for this proposal is all triggered off of a conditional offer. Any thoughts on that?
That's a good question. Go ahead, Josh.
Yeah, and that was also debated at the mayor's roundtable. And I think Commissioner, it's one thing for me to give my opinion, but it's probably better to have the folks that are on the invited panel and then folks testifying to answer that, because they have lived experience actually in those situations, whereas I don't. But I will tell you that one thing that we heard, because we've asked that question too, is how is that situation different than a parent, either a mother or a father, staying home, being a stay-at-home parent?
Big reason, big difference.
Well, and perhaps.
Nothing in the current law prohibits you from saying to someone, I see a 20-year gap. and the person saying, yeah, I raised a family, I traveled the world, whatever. That same question in this context triggers a response that then has an administrative consequence. And then gets us into an area that this particular proposal cautions us against. So that's a big difference. And I'm just telling you, since I spent a long time being an employment lawyer, that is the first place people look, is to the resume. And if there's a big gap, that's a red flag.
In that I agree. We will avail ourselves of having someone from the National Employment Law Project Skyping in as testimony, and I would encourage you to ask her that question as well. It also will lead into a discussion, I have no doubt, over the bigger issue of voluntary disclosure. Because as you may remember from the last time we were at council, that was a particularly big issue and a pretty controversial one. And I would imagine that through the course of this evening's hearing, you'll hear the pros and cons of addressing that issue, which your issue is wrapped up in, I think.
Judy, final question. Under the state law that kicks in January 1, what is the remedy for a violation, first violation? And under our proposal, what is the remedy for a first violation?
So the answer is going to be the same for both. We are mirroring the state remedies. And I'm going to bring you to Oregon Law Statute Number 659A, 850. The state law and our proposed code use 659A, the remedies and complaint process, starting with 820 and going only until 865. That's part of the Scrivener's error that was mentioned earlier. So we're starting with 820, which talks about the complaint process, and it moves through 865, which is retaliation. So in terms of remedies, they can, and I'll also direct look at sort of the Bowley's shortcut on how the process happens. So remedies can include up to cease and desist orders, acts and series of acts designated in the order that are reasonably calculated to carry out the purpose of the chapter, or in our case, code, eliminate the effects of the unlawful practice, including but not limited to paying an award of actual damages suffered by the complainant and complying with injunctive and other equitable relief. Goes on to talk about submitting reports to Bowley on complying with a cease and desist order, for example, like how many folks. So this is what exists in the state law, and we would be mirroring these remedies.
And all of these are pegged to a withdrawal of a conditional offer? So
In the code, yes,
So
the
in our
proposal is.
system, if a conditional offer is made and then withdrawn, that's the triggering event that could allow you to go to Bowley and say it was withdrawn for an improper reason?
Yes, but you would have to meet the threshold of substantial evidence, as you mentioned earlier. There are investigators at Bowley who would accept the complaint and review it for a substantial evidence
And if you
threshold.
if you jump the gun under our proposal and ask the question, and it's determined you solely denied employment to that person on that basis, then that's an unlawful employment practice.
It is, sir.
So that's the risk of someone jumping the gun and having that be the only reason that they did not move forward with that person's application.
Yes.
Okay, any other quick questions before we call on our panel?
Yeah,
We'll get staff back up to.
Well, I have some questions. I don't know if they're going to be quick, but I have some questions that I'd like to ask now. So I guess my overriding question to you, Mayor, really is, so when we first had this hearing, I don't remember when it was, sometime. March, okay. We all talked about the Holy Grail being, God, if we could just really ban the box. And we were told we couldn't do that because employers have First Amendment rights to do that. Well, so the legislature stepped up and actually banned the box. So I'm trying to understand why are we here today looking at doing a city ordinance when the state did, I think, what we consider all to be the Holy Grail.
I think the people you're going to hear from next are going to do a better job even than I will of explaining that. So I want to try to be respectful of the people we've invited here. And again, I think I'll answer that question, but let's let them answer it first.
Okay, so there's no private right of action in this city ordinance?
No, there's not a private right of action. 659A, 865 is the statutory provision where it ends, and that's retaliation. The next 870 is election of remedies, which include private right of action. So the ordinance proposal, the code change proposal, and the state law stop at 865 retaliation. They don't go to private right of action.
So if an employer, you're prohibited under our ordinance to access somebody's criminal history prior to a conditional offer. So what if they, what if somebody Googles somebody's name, which everybody does this. I mean, everybody Googles everybody else these days. Everybody's nosy. So what happens if an employer does that?
I think that's something that I think we'll discuss if the code changes are enacted under the administrative rules, because certainly that is a possibility.
I mean, isn't Googling a First Amendment right too? I mean, I have the right to Google anybody at any time, don't I? Google or other form of social media, I shouldn't brand it exclusively. But
Yeah, well, and Commissioner, I would have to imagine, although I don't know, but I would have to imagine that the vast majority of ex-offenders wouldn't show up on a Google search as being an ex-offender. Those records, you would have to actually conduct online a private background check to do that. I know several,
Well, I mean,
quite a
what
few
if-
ex-offenders who I know if I went to Google them, I would have no idea that they were ex-offenders.
what if it's a sensational offense?
Yeah, it's going to show up.
Yeah, it's going to show up.
Yeah, you're probably going to know that generally anyway. I mean, we can't,
By Googling.
or just by reading the paper.
So I guess, and I know there's going to be rules that will deal with this, but do we want to say that an employer is prohibited from intentionally accessing somebody's social media background or background via social media?
Well, we should consider that.
Okay, so I guess I would put that out there as a potential amendment. And then I just have a couple more questions. So I was curious, so if somebody, it's a position that involves a landlord, or maybe somebody having access to master keys to apartments and things like that, is there a prior screening short of the conditional offer that an employer is able to do when the position's sensitive, or if the crime involves, I don't know, embezzlement or sexual offenses, something like that?
Commissioner, to answer your question, if you look to the exceptions under 2310-040, I'm proposing that might fall under B2, positions which have been determined by administrative rule to present heightened public safety concerns or business necessity.
Right. So if you're a remodeling company and you send crews into people's houses, that's a business necessity.
Okay, but you're saying that may be considered in the rules. I guess I'm saying it seems like it should be. I mean, is there any doubt that a position like a remodeler or a landlord's on-site management or off-site management who has keys should be subject to some higher level of screening? I mean, okay.
Exactly.
Yeah, and I think
We're not
that's,
going to see these administrative rules, are we? They're not. I know
Yes,
we have,
they have to be publicly vetted.
but do they
They're
come back to
written by,
council?
they don't come back to council.
Yeah, right,
They're,
okay.
they're written by the city attorney's office, but there is public comment.
Public comment, okay.
and there was, Commissioner, we had a work group that met after the March hearing. And it was always, I think, the mayor's intention to convene that work group. Initially, actually, it was the intention to convene that work group to craft the administrative rules after council were to pass the ordinance, were it to be passed, and to do it with the attorneys and give advice on what should be considered business necessity or not. And I think that's still the intent, is to bring the group back to actually then fill out the details. One thing we did address during the work group was employment agencies being kind of a strange creature when it comes into employment law. And you won't see that spelled out in the draft ordinance because we decided it goes in under the business necessity. We have a fix for it, but that would come in the administrative rules.
So my last question is the issue I think we just touched on briefly, and that is the voluntary disclosure. If I had a big gap in my resume, I might want to tell the employer at the outset of the first interview, I have a conviction, I served some time for embezzlement or whatever. So what happens if somebody voluntarily discloses that thinking they're doing the right thing?
Yeah, and, truthfully, Commissioner, this was an issue that I wrestled with from the very beginning as well, because practically it seemed to me difficult if you're an employer and someone is doing that for you to ignore it. And I couldn't quite wrestle with, well, I understand the intent of not having that in there, but how then practically do we allow that? And someone who will be coming up in the invited testimony, I think, made a really good case, at least to me, convincing me that there are ways around that of actually saying when that happens, because ex-offenders currently are being told when they are still in prison that they're supposed to disclose those things. But then when that does happen, for the employer to have, I know Judy will get irritated if I say this, but a safe harbor provision of saying, we will discuss that at the conditional offer phase. Right now, we are only discussing your qualifications for this job. And to me, that made sense. I think there are ways that we can actually finesse that in the ordinance or in the administrative rules so that employers know what they're supposed to do in those situations. And during the education period of this, work with the social agencies that actually do train offenders who are about to become ex-offenders on no longer offering your voluntary disclosure at the very beginning. And you'll hear, I know, from National Employment Law Project, that for them, this is a massive issue. And I'm sure Michelle will do a much better job of explaining it than I have. But I went through my own evolution on that issue, too, because it's a difficult one.
Okay. And just one last question. Or did you want to say something?
I just wanted to help Josh a little bit.
We all do.
Thank you.
So employers are very sophisticated in their hiring. If a person of color or a person in a protected class walks in, they know immediately that they cannot discriminate. They cannot use their characteristic to discriminate. If a person who is pregnant, very noticeably pregnant, comes in for an interview, the employer knows and is already sophisticated enough to understand that they can't not hire that person for that reason. Someone wheels in a wheelchair, etc. So this is a similar thing. Sometimes we know things that we're not allowed to use in our decision-making process.
So my just last question is,
Please.
is a conditional offer, I know there's a definition of it, but I guess my question is a conditional offer exclusive to one person, one offer to one person? Or can there be, I don't know, can you have multiple conditional offers out?
I think this is about one transaction, which is an employer and a prospective employee, so they're one at a time.
So a conditional, an easy example is, on your resume, it says you type 70 words a minute. You can have the job on the condition that you take this typing test and you can actually type 70 words a minute. So it's, you have the job, and here's the condition that has to be met in order for you to really have the job.
Okay.
I mean, I think nothing would prohibit an employer from making several conditional offers for the same position, but that would probably be a disaster because then you could have 5 people accepting one job. So it's probably unlikely.
All right, well, thank you all. Stand by. We'll no doubt have more questions unless.
I just want to underscore one of Commissioner Saltzman's concerns. I mean, we know there are employers looking at the language that it's not an unlawful practice if an employer determines in good faith that a specific offense or conduct is job-related for the position in question and consistent with business necessity. And some employers are asking, well, we'll be litigating endlessly over what that means. So I do think it's important that we're going to try to refine that a little bit and give people some guidance in administrative rules.
Yes. Okay, good point. Thank you. All right, thank you all. We'll have you obviously back here a little later, I suspect. Let me call the first of our invited panels, which is Nikinge Harmon Johnson from the Urban League, Emmanuel Price, and Representative Lou Frederick. So if the three of you would please come up, we can get this discussion furthered along. Thank you. Oh, somebody left their, Judy? Judy, I think that's yours. Thank you.
Works for me. Thank
Hello, Mayor.
Good afternoon. Good afternoon. I think you're on first, Nakinga, unless you want to defer to the elected official to your right. He's deferring to you.
He said I couldn't.
Or the spirit of Portland Warrant winner.
Head of line.
So, good afternoon. I am Nakinga Harmon Johnson, and I'm pleased to be before you on behalf of the Urban League of Portland, of which I am the president and CEO. You will see around the room supporters of the Urban League of Portland and also members of my staff. I thank all of you for being here on this important day. So, we heard a little bit earlier about the fact that our state has recently passed a ban the box law. So why then does Portland need a ban the box law? That's the question that seems that some commissioners and other folks have been asking. What makes our city so different from other places in Oregon that means that this law would be a good thing to have in Portland? Why is it urgent that we pass the law now rather than waiting to see what happens with the state version? Those are some questions that have been tumbling around, I imagine, in some of your minds, but also for others outside this room. So here are some facts that help lead us to an answer. First, there have been some recent studies, one in 2015 that I read and another from that occurred in 2014 by the Council of State Governments Justice Center. It's a nonprofit organization that helps to advise policymakers at a local and state municipal level. And that center found a few things. Both Black and Hispanic men were less likely to receive a positive response from employers, including a callback or email for an interview or job interview or job offer compared to white men. And this is after they did a study with similar resumes, just different names. Instead of Bob Jones, it was Roberto Jimenez. Instead of Roberto Jimenez, it was Kwame Johnson. But other than that, these resumes were on par. And they found that white men were more likely to get a call back. Men with criminal records were more likely than women with criminal records to receive a negative response from employers. White men with a criminal record had more positive responses than Black men with no criminal record. Let me say that again. White men with a criminal record had more positive responses from employers than Black men with no criminal record. 80% of Oregon's Black population lives in Portland. Black Oregonians are 6 times more likely to be incarcerated than white Oregonians. I won't presently discuss the reasons behind some of the systemic injustices that happen in our criminal justice system, but African Americans in the state are 6 times more likely to be incarcerated than white Oregonians. While Oregon's statewide unemployment rate continues to decline, the economic recovery for African Americans is far slower. The Urban League of Portland recently released the State of Black Oregon report, with which some of you are familiar with. In that report, we talked about the fact that the unemployment rate for African Americans in Portland is 21%. When the overall unemployment rate in Oregon was 11%, we considered that to be a crisis. And yet, Black folks in Portland are dealing with far higher numbers, and we're not treating it with the response that it deserves. Portland is indeed the hub of Oregon's communities of color. And as such, you as elected officials representing Portlanders have the greatest responsibility to address those unemployment rates and to do what you can to change those numbers for Black Portlanders and for others. So why do we need this ordinance? Because we know the playing field is not level for people of color. We know what the data tells us, and I'd be happy to provide citations for your offices if you'd like to follow up on those facts and figures. Folks who look like me already start from behind. If you then add a conviction to their history for whatever reason at whatever time, for which they have served their time, done everything that we have asked them to do, and come out with training, prepared to work, to take care of themselves and their families, they are still then saddled with this additional burden that makes it hard for them to do so. And there's someone far more learned on these issues than I from NELP who will speak to you later, so I won't go too deeply into this. But the idea of talking about a gap in employment, certainly there are different ways to talk about that. And we know that parents, for example, don't have to say, I was at home taking care of kids. Because there are some studies that say if parents do reveal that information to a potential employer, they too will be dinged. There's sort of the mommy tax that happens. I don't want to hire this lady because she's got kids at home, and that means she might be out more often from work. So even moms don't necessarily aren't in the best situation when it comes to addressing an employment gap in their initial letter to employers. So imagine what that means for people who have convictions in their past. But there are ways to deal with it, and the ordinance that we're discussing now is one step along the path. So we've been working on this issue in Portland for more than a year and a half now. It started in Portland, and then the state was smart enough to pick it up and run with it. And then it fizzled out a little bit on the state level. That's okay, because we know that we here in Portland can pick it back up and do what needs to be done and show the kind of leadership necessary for the people who live here, even if folks in the legislature couldn't quite make it happen. The next step after we pass this ordinance, which I hope you will each support, is for the Urban League and other organizations like the AFL-CIO and other partners of the Fair Shot Coalition to then go out into the community to educate folks who this ordinance will most help. That means employers. It also means potential applicants, folks who have given up looking for work because time and time again they found their application in the circular file before they even got a chance. Before I close, let me say one more thing. When we think about the kinds of jobs that are most often impacted by a rule like this, it can sometimes be hard for middle-class folk like me to get a real big picture of that. I imagine the same can be true for you on the council, even though you deal with these issues at least as often as I do at the Urban League. We're not necessarily talking about the candidates for the Urban League of Portland presidency. We're not necessarily talking about those who would be a partner at a law firm and what Ban the Box might mean to them. I, as an employer at the Urban League, certainly hire folks to work with youth, to visit senior citizens in their homes, to deal with vulnerable populations on a regular basis. That is the work that we do. So I understand the employer position of wanting to have the right people in the right jobs to keep the folks they serve safe. It makes all the difference in the world, and I get it. I also know, however, that there are plenty of positions that I do hire for that it doesn't make as much difference as you might think what someone's history of arrest or conviction is. And even though I, at my little nonprofit, I don't have an HR officer, not a coordinator, not an HR assistant, I can figure out how to make this work, and we already have at the Urban League. Because of that, I am confident that other companies in our city, as progressive as we are, as right-minded, as smart, and as many resources that we have at our disposal, can find a way to make this work too, for the benefit of all of us. And it's one way for us, for this council, for this city, to tackle the racial disparities we see with unemployment in this town. Finally, I'm prepared to work with folks who've had some challenges around this ordinance. The Portland Business Alliance and the Urban League have considered whether we can work together to help educate employers, or whether we can work together on the things that we do agree on when it comes to Ban the Box and creating additional opportunity for folks to get jobs. We don't see eye to eye on all of these details, but we too are prepared to do the best we can to make this work, because we do agree that it's better for folks to be working. It's better to folks to have jobs than it is for us to spend our tax dollars locking them up. And if they're not working, we know the recidivism rate is far, far, far too high. Thank you for your time. I look forward to your questions.
Thank you, Kincaid. Good afternoon, Representative Frederick.
Good afternoon. I'm Lou Frederick, the state representative from District 43, that's North and Northeast Portland. Hello, the mayor and the council. Good to see you. As you all know, the legislative process is really one of compromise, and those that come in with a position that they will settle for nothing less than all of what they ask for, those who basically say all or nothing, usually end up with nothing. It was important in crafting this law to get something. When enacting a law such as this one, it's not just compromise between positions, it's also compromise among different Oregon communities with different needs. This law needed to work for the whole state. So the something we got should be seen as a base on which local jurisdictions can craft policies that fit their communities. I don't need to rehash the evidence about how black and brown folks' experience of the criminal justice system is different from that of white folks. I don't need to rehash the evidence, either anecdotal or statistical, that every step in the process, from the possibility of a stop to the finality of a sentence, tends to be more harsh for certain members of our community, particularly those who are identified by some measure as other. And the reality is that every felony conviction carries a lifetime sentence, a sentence to facing an additional steep hurdle on the path to housing, employment, or education. Incidentally, that lifetime sentence is rarely understood during the plea bargaining process. Now, whenever someone completes his or her sentence and re-enters society, all of us have a stake in his or her success. Lawful economic opportunity is the foundation for building a life as a net contributor to a community, and that usually means employment. Barriers to employment are also barriers to family stability and to neighborhood peace. I'll be proud of my city for taking this additional step, building on the base set of the legislature, to delay asking that question about prior convictions until the potential employer has a good look at an applicant's qualifications. The chance to convince an employer of his or her worth based on knowledge, skills, ability, and enthusiasm may be the most important thing we can do for an ex-felon seeking to get on the right track. I urge you to move the timing of disclosure to the conditional offer phase of the application process. And I also want to say something else. We are, I hope, starting to turn the corner on how we address what's happening in terms of criminal justice, to a point where we're no longer deciding that the primary role of criminal justice is punishment for the life of the person, but in fact trying to find a way that we are going to try to make sure that people are reintegrated into our community and are getting along well, so that we are all getting along well. That's the approach that I think this begins, and I hope that we begin to do that. I want to thank you for giving me the time to talk with you about this, and frankly, for taking up this ordinance.
Lou, can I ask you a question that you're uniquely suited to answer?
Okay.
Because you're our representative from the legislature. So the House passed one version of ban the box, the Senate passed another version, and ultimately my understanding is the Senate version prevailed. And that's why we've heard that the legislature may not have, quote, made it happen as the Urban League would have wished, because I think the House version was the Urban League version, the Senate was a different version. We're used to being preempted from acting in certain areas. There's a reason it shows up on our legislative agenda every year to lift these preemptions, because the legislature in its wisdom keeps handcuffing us on things we can't do. My understanding is that Senator Winters and others could have insisted on a preemption when the state statute was passed, which would have precluded us from having this conversation. Since this is a slightly unusual situation for us of acting ahead of the state law even taking effect, what guidance can you give us as to what the legislative intent was in not preempting local jurisdictions from regulating in this area?
You are putting me in a very awkward situation here for a couple of reasons. One is, I was not involved in those discussions. I was involved in caucus discussions. I was involved.
By the way, Lou, you're my friend. I'm not trying to put you in an
No,
awkward
no,
position.
no.
I'm just, you're a resource.
There's another awkward position you're putting me in. I hope to be moving over to the Senate, so I have to be careful.
Wait a second.
I have to be careful about
Strike that for the record.
The fact is there were some significant differences between how the Senate was approaching this and the way that the House was approaching it.
Fair enough.
And you see that. And the discussions within the Senate chambers and the Senate committees were something that I was not privy to. And why one path was followed by Senator Winters or others is just simply unknown to me. I know that there were lots of discussions. I know that they were heated discussions. But in terms of the approach, I think we're going to see, by way of how well this ordinance works, or how well this ordinance is put into place and works, a question on whether whether it might be able to move along in other places. And frankly, the city of Portland, as I said, you as a council, you make me proud that we are bringing this up, because it begins to focus the attention on this issue statewide. And that's an important factor. How you decide to handle it, and the rules and regulations that you come up with by way of your administrative rules is going to be important as well, because other people are going to try to follow that, or at least see if it works. And so you're going to be seen as not just a model, but It's going to be how well do they do this? How well does Portland handle this situation? And passing that along to the House and to the Senate is going to be a different issue for you. But it's also going to be something that's going to be very important for how we work on it at the state level. And it involves, in terms of preemption, you know that I've ended up talking a lot about the preemption issues, both for the city and the county in Salem, because we have some real problems down there in terms of how they understand how to deal with it. But we've also had a compromise take place with the marijuana bill that dealt with how different groups, different communities wanted to deal with sales. And that's part of the compromise and the discussion that takes place. So that this is an ongoing process, and I don't expect that we're going to have a final say on this, but I'm really looking forward to see how well the city of Portland handles it.
Thank you very much. I don't think that answer is going to get you in trouble to say.
Oh, yeah, well.
Future Senator Frederick, to the extent that you can engage in this process without offending your future colleagues, I'd ask you to help in explaining the kind of conduct that we're afraid might still be allowed under the legislative bill, but that wouldn't under this ordinance. And I'll just throw out what my understanding is one of the major concerns is. The legislature simply banned the box in the initial written application. It's my understanding that the legislative action wouldn't prevent an employer from asking as the first question out of the box, Scott, no pun intended, in the interview, do you have any criminal history?
That part of the discussion was something that was part of the discussion in the legislature, and how you handle that. I think that your ordinance will take the next step, and I think it's appropriate to take that next step and see if we can in fact get that accomplished, so that we can see what really happens rather than the hypotheticals that get thrown out rather constantly. I think you have hit upon an approach that says, let's wait until you can see what the skill set is, what the talent, what the enthusiasm is for a candidate before you start to try to eliminate them. And I know that there's a desire to, just in terms of time, I don't want to have to deal with this number of people. Well, okay, I understand that. But, at a certain point, we've already seen what that does. It really doesn't matter. I've in my past applying for jobs in Oregon, in Portland, I recall my application being thrown out, and then going back to the same institution and finding out that they had lost it, and then they lost it and they lost it and they lost it before I even got a chance to talk with anyone. I think that this allows us to begin the process of changing that level playing field. That's really getting to that. So that's how I look at that. I'm sorry, I really can't see a problem with waiting until you make that decision.
Ms. Harmon Johnson, since you don't have to worry about offending your fellow legislators, am I outlining one of your concerns about the legislative language in saying that it would still allow an employer as the first question in an interview to ask about criminal history?
Sure, it means that nothing much has changed, right? As an employer, I am looking for ways to exclude candidates at the initial and even at the second phase. Often when I post a position, there are far more candidates than I have the time or interest to interview. So I'm looking for reasons to not interview people. I'm looking for reasons to not schedule folks to come in the door, whether it's typos in their resume or something else, right? So when I do get folks in the door, if I've had to, whatever it is, I'm still looking for ways to figure out who's not the right candidate. So then I can zero in and really spend some quality time with those who are the right candidate. So thank you very much, Mr. Novick, for your application. So have you ever, been convicted of a crime? That's great. Thank you very much for coming in. You have a nice day. Amanda Fritz, thank you very much for coming in today, and so on and so forth. That will certainly save me some time, but it doesn't do much in terms of changing the game for the candidates who have served their time, who are ready and willing and able to work, and who should have at least the opportunity to tell employers who they are, to show their skills and their talents, as Representative Frederick just mentioned. That's what this ordinance does that the state legislature failed to do in its work.
Thank you very much. Mr. Price, welcome back to the council chambers.
Thank you for having us. So my name is Emmanuel Price. I'm the founder of SCAFE, Second Chances Are for Everyone. It is a nonprofit to help men and women after they get out of incarceration. It may sound a little jargony, but I just want to read and make sure I hit every point. So while state law to ban the box was important, it simply removes the box from job applications. People with histories are often encouraged to honestly disclose their histories. We need an ordinance in the city of Portland that can actually connect people with past convictions to jobs that will build better families, stronger communities. These entry-level positions are the jobs that are most desirable and accessible for those with felony backgrounds. And when we, because I am a convicted felon as well, when we voluntarily and honestly disclose our background on applications, the opportunity for an interview is decreased by 100%. The opportunity to gain employment is also decreased by 100%. This I know to be accurate because I serve the population of people that I'm speaking on behalf of. And we all have the same scenario when it comes to looking for jobs, employment, housing, healthcare, even education sometimes. Not only is this true for me, as a person with a felony background, my conviction is 19 years old. And as a 38-year-old single father, it creates unnecessary barriers for me. Over the years, it has hurt me and hindered me when I haven't been able to provide for my family due to the barriers that have prevented my consideration for jobs that I've experienced and the skill set to do. This is an opportunity for the city of Portland to help increase employment opportunities for those who have past convictions that apply for entry-level positions. With this ordinance and support, unstable communities become more fragile, people become more dependent on social services, while less likely to be employed. Lastly, this may sound a little snarky, but with all due respect, no, seriously, people are able to vote immediately when they are released from prison. So the same people that we're talking about can vote each and every one of you into office and have actually put their ballot and voted you into office. So we trust when we put our ballot and when we vote and when we sign our signature, when we vote for you, or you, that you will have our best interests at heart. And when we cast those ballots and we vote and we see people in office, and then we come and we make this case for a simple living, we don't even get that. This is an extremely large population of people that anybody can have access to, that should be paid more attention to, because it's a growing population. And when they get out, they can vote for you. They can vote for me. They can vote for the next young African-American Latino person who wants to run for office. So not only pass this ordinance, but also look at it from kind of a selfish standpoint, like, oh, I could do another 4 years, because these people will vote. These people want to vote. We want to get out and work and take care of ourselves and our families. And, lastly, I appreciate the time that you guys are taking to show attention to this. And this is a serious matter. I'm 38, my conviction is 19 years old, but I still have the same barrier when I apply for any job. When I was 24, I applied for a job at Arby's. I thought I was above food service and, I didn't want to be working in that environment, but they didn't even hire me because of my past conviction. And I had been out maybe 4 years at the time. So it's not like people don't want to work. We want to work. Nobody wants to go to jail and sit there and rot and do nothing, but at least afford that opportunity for people to come out and be able to have an interview. Like Michael Alexander said, let us show our work history and showcase our talents rather than be judged on, oh yeah, Mr. Price, you have a conviction. Let's just push that application aside. I live this every day. I'm not just up here speaking from no experience. I work with these people every day, and I hear the same story over and over and over because I live it. So thank you for your time.
Thank you. Any other questions for this panel? Thank you all very much. Appreciate you being here.
Thank you.
Our next panel is Bill Dickey, Tom Chamberlain, and London Elliott. on first, Bill.
My name is Bill Dickey. I'm a business owner in Northeast Portland. I have between 25 and 40 employees, depending on the season of the year. It's interesting. I went back and picked out an application for an employee that I hired in 2004, and I didn't have the box on my application then, so apparently I had self-banned in this situation. And I do have employees involved in the company who have criminal backgrounds. I think that we, in general, life's about second chances, and just continually getting second chances when you make mistakes. But this ordinance that I'm in favor of takes it a step further than the state law and sort of educates us moves the employers and teaches the employers to do the thing that isn't obvious. In other words, right now it's obvious, and it was a great example. I'm not sure the woman's name, the city lawyer who was here, who said it's obvious when a woman walks in and she's pregnant, you're not going to ask her questions about, whether her pregnancy or her family are going to be deterrents to her job. This rule of asking this question after you make the decision is just sort of a way for us to move ourselves a little further along and help change a societal problem that we have that is something that we're addressing now, which is great. Other things got addressed earlier, but this one is just another thing that we need to do to make our situation better. And it is great that the city of Portland is taking the opportunity to lead the way on this, because we have the ability to do that. And currently right now, this is completely aside from this, but there's stuff going on social media right now that is just crazy ever since the Paris attacks, and that kind of prejudice that's going on. It really bothers me greatly, and it's embarrassing. And I honestly sit at red lights on occasion and think, why do these people think differently than I do? Just in general, because I live here and I love this place, and so anyway, I just think that this is a great opportunity, and I'm definitely in favor of it. And I'm also a member of the Portland Business Alliance, in case anybody wanted to know about that. I guess that's all from me. Thank you.
Thank you, Bill. London, would you like to be next? Welcome back to council chambers.
Thank you so much. It's nice seeing you all again. As you said, my name is London. I'm 18 years old, and I'm a third generation born and raised Portlander. My father, my brother, and several other family members have records. To me, that has been a life of unemployment resulting in instability for all of us. Not having access to employment changes how society, your community, and your family sees you. Most importantly, how you see yourself, resulting in a lack of confidence, opportunity, and hope. This despair affects every relationship in that person's life, such as relationship between parent and child, taking away one of the most fundamental relationships in life, and far too often setting the stage for that child to repeat the path of the parent. Growing up, I experienced what it was like not having access to employment. I had the fear of coming home from school to see eviction notices and past due bills. Have you guys ever eaten sleep for dinner? You guys know what that means? That makes you feel powerless, especially since you see your family trying so hard. Mass incarceration and subsequent joblessness is a problem all across Oregon. But if I'm being honest, it's reached epidemic levels for my community here in Portland. In a city like Portland, where far too often I see people who look like me treated as if they are guilty until proven innocent, many of my peers and friends are already on a lifelong journey towards recidivism and chronic unemployment. This is something that the city of Portland has the opportunity to fix. Oregon already took the first step, but Portland can lay down a path towards success for people like me and my community. I urge you to pass this ordinance without delay and help thousands of families like mine in Portland. Thank you.
Thank you. Mr. Chamberlain, welcome.
Good afternoon, Mayor Katz, commissioners. Oops,
Now, that
you know
was
what?
an
I was
interesting
thinking about that.
Whoa, wow. Tom?
I've been at this job way too long.
That's high praise, but
Yeah.
it's been
Mayor Hales, glad to be here too.
Stop right there.
I'm here today on behalf of the 300,000 men and women of the Oregon AFL-CIO and encourage you to take swift action on this ordinance. We represent a broad coalition of groups that have come together to advocate to ban the box. And previous testimony, you heard that the state of Oregon has taken an initial step, a critical step, an important step, but a step that doesn't go far enough. It may be a good policy, but it's not an excellent policy. We're the city of Portland. We believe in second chances. We're the city of Portland. We're a national leader. We're the city of Portland. We just don't go along to get along. I expect great things from the city. And moving forward with a policy that just mimics what the state did isn't enough. We need a policy that really does something, that really gives ex-felons a second chance for a better life. And while this may be more than other cities have done, other states have done, it's important that Portland does more than they do. We encourage fast action on this. We support this. Thank you.
Thank you. Thanks very much for your help. Thank you all. Questions? Thank you all very much. We have one more invited speaker, and we'll see if the technology supports her arrival, and that's Michelle Natividad Rodriguez from the National Employment Law Project. So I believe we have her set up to Skype in. We'll see if that actually works. Carla is attempting to make that connection.
PCM is doing that.
Okay. Give us a moment. Good afternoon, Michelle.
Hi, everyone. Can you hear me okay? Okay, great. I am having trouble hearing you, but I can go ahead and share some thoughts. Thank you so much for having me and using the technology to get me in here. Just a little bit of background about myself. I'm a senior staff attorney with the National Employment Law Project, and we've worked for the last several years with jurisdictions across the country, policymakers and advocates on fair chance laws and ban the box laws. And I myself personally was involved in the San Francisco Fair Chance Ordinance, and I worked 3 years on that. I worked 2 years on the California legislation personally as well. That was just a straightforward ban the box, and have been involved in a variety of the movements that have happened, including recently with President Obama's announcement that did apply to federal agencies as well. So that's my background, and what we tried to do in situations that policymakers like yourselves are facing is to gather the information about what's working, what's not working, and to help you in ensuring that you are doing what you can with the goals that you want to achieve, which is, I think, what we can all agree on. We have a broken criminal justice system. We have seen the impact on our community. We have heard the heartbreak and pain, just even in today, of what that's caused. And so we are committed to doing all we can. And that means getting people jobs. That means taking away the unnecessary barriers. And so we all have that shared goal. And then the question becomes, how do we do that well? How do we make sure that the laws that we can put in place will actually accomplish that goal. And I just want to evoke a little bit of what Bill shared from his perspective as a business person that I thought hit it right on the head. What this law does, what it has the opportunity to do, is really educate employers and teach them how to take the bias out of the hiring process. It starts to address how can we make a cultural shift, because really what we're dealing with, as you heard from Mr. Price and others, is a deeply stigmatized population. And because of that deep stigma, we have to take very seriously having the laws in place that are going to make an impact. So that's our starting point. And what I want to do is just cover a couple of details that have been raised. And I have been listening in, and there were a few questions that were directed my way. So I will try to address them as well. One point that I did want to share that I noticed, which I think is a very common misunderstanding, and it comes into your question of thinking about exemptions. I heard references to when there are these heightened public safety concerns, we need to ensure that we have enough exemptions. Now, I just want to point out to everyone, and I think that this is a very natural misunderstanding, is that your process, the laws that you laid out here, even without the exemptions, makes your hiring process and your public safety concerns, addressing those, no less rigorous. Alameda County is an example of a jurisdiction that has had this in place since 2007, when their HR person came before the California legislature about their experiences with a more comprehensive fair hiring law that included the conditional offer threshold. They made it very clear this did not change how rigorous their process was, even in heightened safety positions. And when I think about as well the example of some of the most safety sensitive positions in our country, which is under national security, I will just also point to the fact that the Office of Personnel Management, who is in charge of those national security jobs, also recommends waiting to the conditional offer stage before a background check is given. Now, why is that? It's because it does not change the fact that you can still do the analysis that's needed. The benefit of that, just period, is what we've seen is that for most of these jobs, what you're going to find is most convictions that people have are not going to be job related. And I point to the experiences in San Francisco. They recently released a report under their current analysis of how their jobs are considered. And they found of the amount of people that had conviction records, when they did their own job analysis and looked at job relatedness, in the end, they only found that 2% total should be disqualified. So it's all to say you have a very low percentage, if you're actually looking at job relatedness, of individuals that should be disqualified from a job position, period. So those are some of the broad points that I just wanted to cover. And then drilling into a couple of questions that were raised. There was a question about voluntary disclosure. And I actually thought that Judy and Josh did a great job of addressing that. The concern with a voluntary disclosure and having that included in the law is that you're not really going to see the kind of cultural shift that the law is intended to create, which is that you want this conversation to happen after the conditional offer phase. The reason for that is because you're trying to minimize the bias in the process. And the way that other jurisdictions have handled this is much as the way that Josh and Judy described. You can do it with a notice at the beginning to indicate that any discussion of a conviction record will happen after the conditional offer. That's the path that San Francisco has taken and some others. You can also say, during the job interview phase, right at the beginning as an employer, we're going to talk about the background check, not at this time. So there are very simple ways to deal with that. And the benefit of it, of course, is that you're really aiming at the kind of cultural shift and the debiasing that the hope of these laws are trying to make happen. You're getting closer to that. I also just want to harken back to a point that one of the commissioners made, which I think is a very important one around enforcement. We've found with jurisdictions across the country that really the difficulty is not with employers, facing a gotcha situation. Employers are finding that they can meet the standards such as conditional offer and job relatedness just fine. The problem has been enforcement. We are not seeing as many people coming forward. There's a lot of reasons for that. One of them being that already job applicants, people with records, are in vulnerable situations. You're already dealing with individuals that are not going to be as willing to come forward. So keeping that in mind, we want to make sure that we're not getting into a situation of he said, she said, as the commissioner indicated. We want to ensure that enforcement can be as solid as possible. And just generally, that's something to keep in mind. You don't want to be in the position that some jurisdictions are in now, which is trying to go back to their prior law to make improvements so that it's not a law in name only, but it's actually working on the ground. I'm happy to drill down into any further questions that you may have or any particulars. We do have a lot of materials and experience with other jurisdictions that I'm happy to share.
Michelle, thank you very much. I think there are a couple of questions from members of the council, so hope you can hear us.
Ms. Rodriguez, can you hear us?
Yes, sounds like she. You're her now. Well, we'll see if we can make this work and see.
Can you hear us?
Yes.
So it's Nick Fish, and I appreciated what you said, just your most recent comment about the he said, she said. And I'll just give you an example. I, in a prior life, represented someone who had a claim of discrimination based on retaliation for opposing HIV discrimination. It was a retaliation claim. And the key evidence in the case was the employer putting in writing the reasons for the termination. And because the reasons were legally insufficient, it was the key piece of evidence to show that they didn't have a good faith basis. And so that's what is in the back of my mind. Is it unduly burdensome to require, in your judgment, to require that the withdrawal of the conditional offer, the explanation for that withdrawal be in writing?
I don't believe it is so, for the very reason that you mentioned. If this is going to be something that you have working in practice, we have to think of the mechanisms to ensure that it does. And certainly to be able to say in writing, this is the reason for the denial, helps ensure that the employer is going through an analysis. And as well, it can help the applicant see what the issue is, and it will help enforcement. In the end, by having that clarity, I think that everybody in the process will not have to go through the back and forth of the he said, she said, which would just take the enforcement agency's time to try to figure that out. You get the benefit of clarity with writing, and I think that that's what your point is trying to say.
And I assume that it doesn't matter what form the writing takes, whether it's a document, an email, or whatever. It's something in writing.
Exactly. I think that the point being that we have some kind of documentation that indicates what the rationale is, even if it's very simple. There's some jurisdictions that have even provided a copy of the background check and literally highlighted what the issue was. It can be as simple as that.
One last question. When you look around the country, what's an example of a city that has gotten this right? And how do you measure success?
It's a very good question. Thank you for that. Part of the larger issue here is that we're not seeing a lot of cities and counties, and I sympathize, but we're not seeing a lot of them collect the data. And so we are not seeing what the problems are as clearly. What we'll see is the number of complaints that are filed and how those are resolved. But I do encourage you, for what you can, for your contractors or for the city itself, to actually look at the number of people that are being hired who have records, so that at least you can identify yourself, is our law working? Maybe that's not as practical for the employers themselves, but it is something we're trying to explore. So that's kind of a side note. This larger question of what I've seen working from jurisdictions are a couple of points. One, the District of Columbia, in their ordinance, which became effective in December 2014, which does have the conditional offer threshold, has stated in a letter, I think that you may have that letter, in fact, that the conditional offer threshold has been very helpful for their enforcement. As well, they've had an amount of penalties go to complainants. Now, the reason that they had a certain amount of penalty go to complainant is for the very reason that I alluded to earlier. Workers that are low income, that have records, are not going to have as much time, period, to come forward and make a complaint, especially if they don't see how that's going to get them that particular job immediately. So you're asking individuals who don't have a lot of time, who need to take care of their family, to come forward to a government agency that they probably don't trust, to make it better for the next people after them, which is a wonderful altruistic thing to do, but it's not something that a lot of people have the luxury for. And so in the District of Columbia, they found that by having that small amount of the penalty go to the complainant, they're actually compensating people a little bit for their time that they are giving to help ensure that the law is being enforced properly. I will also say that I have been impressed with the outreach and education efforts and the dedication of resources for that, for Seattle, for the District of Columbia, and for San Francisco as well. One of the things that hasn't worked as well for San Francisco is that they have very low penalties. And it's not to say that they aren't working with employers, and most employers don't mean the best and won't try to follow the letter of the law. It's just very difficult for them to have employers who are not taking the law seriously pay any attention to them when their penalties are so low. So their hands are tied as an enforcement agency in that regard because of their low penalty structure. And it's probably going to have to be something that we go back and try to change in the law, which is going to be a difficult process. So I would recommend that you don't take those steps and you try to get it right at the first.
Thank you very much. Other questions from Ms. Rodriguez? Thank you so much for being part of this process today, and you've added a lot of value and clarity to our deliberations, so thank you very much.
Thank you.
Let's move now to folks that have signed up to speak, in addition to the ones that we already heard from that were invited. I know that we probably still have a few of you here who would like to speak, so let's go to the sign-up sheet and see who remains.
I have a total of 9 people signed up. The first 3, please come on up, are Mikhail Shabazz, Christina Gage, and Crystal Ilinsky. Let's go with Kaja Rutledge.
Good afternoon, welcome.
Good afternoon, thank you. I am Mikhail Shabazz. Mr. Mayor and Council, thank you very much for this opportunity. I am the director of OICO, the Oregon Islamic Chaplains Organization. We are a part of Mercy Corps Northwest Reentry Coalition, which is a faith-based coalition. We've been in place for about 15 years. We provide in-reach services in most of Oregon's prisons, as well as reentry services for those who are post-incarcerated. And I'm here today to support, not only to support this change in code, but to promote it. I think it's a big step in the right direction for those who are facing the obstacles that we've all discussed today, the long list of difficulties that people face, men and women coming out of these prisons, are endless. And I think it is very important that the education process that's being spoken of here extends itself to the intended recipients, i.e., it's one thing to inform the community outside, but we have to do the inreach on the inside with the individuals who are incarcerated and will be coming out so that they know and understand that this is now a new opportunity or a renewed opportunity for them to find employment, and that there is some teeth in the code that will allow them to, God willing, obtain the employment that they're seeking to obtain. So I think it's very important that we go both ways with what's being projected. And I would like to also suggest, after listening to all this wonderful testimony, that the city regularly encourages inclusion, participation, diversity, inclusion, et cetera, and it somewhat rewards those contractors who comply and who show good faith efforts in this manner. And perhaps somewhere along the line, as you're drafting all these rules and regulations and codes, et cetera, that could be considered as well. That when looking at particularly those who are contracting to the city, if they have the means of being vetted to see if they're actually offering employment to those who are applying that have criminal backgrounds, and if they're offering employment to them and they're doing the outreach and they're making it known that they are open to do business with people and that they are not checking them off at the door, that they also be given some measure of recognition for doing so. And that would perhaps encourage them to be more forthcoming. The organizations that I work with, Miracles, for instance, HARP, which is another organization, Phoenix Rising, Women of Purpose. There are many organizations that are in the reentry community that can utilize this law in our arsenal when it comes to assisting people that are transitioning out of prison and into community life. So to wind it up, I'm here to support it. I think that this is a great move. I understand the dynamics that are taking place. In the city of Portland, I think not only have the opportunity, you as the mayor and the council have the opportunity to set the bar, but also to set the example. I've worked for the city of Portland for 20 years in outreach, recruitment, et cetera, programs through Commissioner Leonard, understanding how to bring people into the workforce that did not traditionally have access through skills, et cetera. So I think if the city itself bans the box and then sets the example, then others will be more likely to follow. So I just want to, again, thank you all for what you're doing. It's very important what you're doing. It's meaningful. It's very meaningful to people to know that they have a chance. Some of the individuals that I deal with and that my organization deal with, we see them go in prison. We started our organization 15 years ago, and some of them are still there on their way out. And we see people that go in with many years ahead of them, and we see the life change. But when the life takes a change, it also needs to have hope that those changes can be executed. And bread and butter, our core values and core issues. People have to be able to maintain themselves. We either work with them, let them know that they can work for us, or they have no other alternative than to work against us. And I'm a businessman also. I have a plumbing company, and it is my protocol also to bring into my shop those who have criminal backgrounds. And in today's society, I think most of us will find we have a little criminal in us. We just haven't gotten accounted for. Thank you.
Thank you very much. Thank you. Good evening.
Hi, Mayor Hales and Commissioners. My name is Christina Gage. I work for a company called Higher Image, which is a background screening firm. I'm also a member of the National Association of Professional Background Screeners, and I'm here today on behalf of the NAPBS. NAPBS represents more than 825 companies nationwide, many of whom work with businesses within the city of Portland, providing the public with safe places to live and work. Our member companies are defined as consumer reporting agencies, and we're regulated by both the Federal Trade Commission and the Consumer Financial Protection Bureau. We appreciate the opportunity to offer our professional insight on whether or not Portland should impose increased restrictions on criminal background checks above and beyond what's already regulated by the FTC under the FCRA, as well as what's impending with HB 3025. And for the following reasons, we are going to say we oppose this change, of course. The biggest issue we're seeing is that this legislation is imposing itself on top of what's already in existence. We wholeheartedly support, NAPBS wholeheartedly supports providing all consumers with safe places to live and work, and any efforts at helping individuals find gainful employment and avoiding recidivism. And we believe that the ban the box in its purest form, as HB 3025 is presenting in the state of Oregon, will do just that. It's going to go a long way in helping to avoid the situation where employers are just tossing out applications. But we really need to consider what the imposition of additional changes to law would have as it relates to things that already exist on the books. So for example, Portland's ordinance goes beyond Oregon's because it's requiring that we state the specific reason or specific criminal issue in the criminal history that's a problem for the employer. Well, we already covered that under the FCRA. We're required, or employers are required, any employer that uses a CRA like ours is required to go through a two-step process before they can either rescind an offer or decline employment if they're using that criminal history as a basis for that decision. So they have to go through the pre-adverse process, which requires that they already send the report in its entirety to the applicant. On top of that, then, they have to give a 5-day waiting period for that applicant to come back with information that would clear up the history if there was a problem on it. It also gives a time period for the employer to consider whether or not that's relevant to the job. After that, then they can take action and do the final, what's called final adverse action, and go ahead and rescind the offer.
Does that have to be in writing, or can it be oral?
It's in writing, and it's all actually regulated. Wording in terms of the whole process is regulated.
With respect to the federal law you're talking about, has your experience been that there's a virtue in having it in writing, so there's no misunderstanding of the reasons?
Correct. Yes, absolutely.
That's the exchange we had with the lawyer and trying to bring clarity to this. So
Absolutely. I mean, the whole process is governed by very specific rules. So, for instance, we have to provide also the employer provides the FCRA summary of rights before a background check is even done. It's provided again at the point that the report is given to the applicant.
I just want to, you've raised an important question, so let me just jump to the chase. Do you believe that our requirement is redundant in light of federal law?
I'm getting there.
Okay.
Try to get there soon, because we're running out of
So in
time.
addition to the
We're running
FCRA,
out of time, so I wanted to give you a lifeline.
So in addition to FCRA, the EEOC already provided guidance around individual assessment in 2012. And they provided that in the form of the publication called Consideration of Arrest and Conviction Records and Employment Decisions under Title VII of the Civil Rights Act of 1964. And in that, they provide the same sort of criteria that you're suggesting, is that you look at the actual crime or crimes, the age of the person at the time, what's its relevance to the job being applied for. So all of that's already in place.
But again, the big difference is about timing. And the EEOC traditionally did not address the question of timing. It was, and they have another stick, by the way, if they think that employers are wholesale barring people at the front door. But it's about timing. So,
Sure.
and admittedly, the proposal on the table has a different timing than your industry enforces nationally. Have you found any particular challenges enforcing the Washington, D.C. law, or any other, or Baltimore, or any other city that has taken the approach that we're evaluating?
Well, I think ban the box again in its purest form, which is saying we can't ask on the application, and even the laws that go as far as to say you can't ask until interview, like 3025 is doing, or if no interview until a conditional offer of employment. I think that those in our experience have been wonderful, not a problem. But it's when you start implementing rules around kind of the subjectivity of me evaluating somebody's criminal record and what is it going to look like? How do I put it in writing in the right way? And we've already talked about it with the EEOC and how that should happen. So I think that's been our issue.
So if the council ends up disagreeing with you on the policy matter, what I hear you saying is that there's a body of law, particularly at the EEOC, that you want us to review as guidance as we do our regulations. Is that correct?
Correct.
Yeah, I hope
That's
you'd
very
be
helpful.
willing to be involved in this.
Absolutely,
regulations
absolutely.
as well.
That's very
Good,
helpful.
Good. Thank you so much.
All right, thank
Appreciate
you.
it. Thank you. And as we call the next group, let's include, please, Sonia Skvarla from Social Ignition, because I neglected to call her earlier. So why don't you call two more, Carla?
Okay, Rod Such and Casey Jama.
Not very long. I think we've only got 6 more. Good afternoon or good evening. Sonia, why don't you go ahead?
Thank you. And if you did call my name earlier, I apologize. I was with a client who's starting a business.
Failed to call your name earlier.
Right,
so-
okay, perfect. All the better. So my name is Sonia Skvarla, and I run a Social Ignition. You've met me before. I was here at the last hearing at Ban the Box. I work with men who are incarcerated at Columbia River. We talk about entrepreneurial ventures and personal development. So I was there this morning, and through a conversation unrelated to this topic, I was meeting with a gentleman, Jamal, whom you know, and he's getting out in a couple weeks. And he said to me today, I'm going to read it from my note, "My biggest fear is to be judged for the person I was at a point in time 10 years ago versus the person I am now." We talk about timing, about the ban the box, when are we going to ask? And I know that's what this hearing is about, and we all make a decision based on really wonderful evidence. But what I'm concerned about is what this comes down to is the intersection between public safety and discrimination. And regardless of when you ask the question, companies are able to automatically disqualify someone on the mere existence of a criminal record. A Social Ignition and my work is about getting to the root issue. What are we scared of? What are we nervous will happen if we invite someone into our business that we have built? And I would like to see more conversations around that whenever all of you work out the details on the timing before or after any of those, is to really sit down with business owners and say, what are you scared of? What are you nervous about? How can we address those things specifically? Whether it's more education, more programs inside, as the gentleman was saying earlier, more opportunities for people to meet and get to trust each other. That's what this is about at its core. And that's what I would like to see more of as you all decide on timing, when to ask the question, when is it okay for me to discriminate against you, and the work that you've done before. Thank you.
Welcome.
Thank you. My name is Rod Such, and I'm reading this statement today on behalf of the Portland chapter of Jewish Voice for Peace. The Portland chapter of Jewish Voice for Peace strongly endorses the mayor's proposed ordinance to remove a barrier that stands in the way of many people seeking an opportunity for a second chance. This proposed ordinance is a significant improvement on recently enacted state legislation and will clarify for many Portland employers the importance that the city attaches to this initiative. Everyone deserves a second chance in life. This is especially true for people of color who face institutional barriers of discrimination and who have been disproportionately affected by our draconian drug sentencing laws in an era of mass incarceration. If you have not yet read Michelle Alexander's groundbreaking study, The New Jim Crow, we strongly urge you to do so. In it, you will learn not only about the racist and political motivations behind many of the Get Tough on Crime laws of the 1970s and 1980s, but also you will become more aware of the lasting impact that felony convictions have on people's lives. These include not only their ability to obtain work, but also to obtain housing and other social services, not to mention disenfranchisement in many states. Why should a Jewish organization weigh in on this issue? JVP is a human rights organization, and equalizing opportunities and employment application is one of the civil rights issues of our day. The civil rights movement of the 1960s lifted all boats. Civil rights legislation made it more difficult for Jewish people to be subjected to restrictive housing covenants and tokenism in hiring and college admissions. At the same time, Jews in this country enjoy white privileges denied to communities of color. It is therefore incumbent on us to align ourselves with those still fighting discrimination and with those still seeking a second chance. Ban the box.
Thank you very much. Thank you. Mr. Jama, welcome.
Thank you, Mr. Mayor, and thank you for commissioners to allowing me to speak in front of you. First of all, Mayor Hales, I want to thank you sincerely for you putting out a statement in support of welcoming refugees in the city of Portland. As a refugee, it meant to me a lot, and it meant to a lot of other folks. And I would encourage all of you other commissioners to do the same thing. We are facing very difficult and challenging time. And again, my name is Casey Chama. I'm the Executive Director of the Center for Intercultural Organizing. CIO stands shoulder to shoulder with Urban League of Portland, AFL-CIO, and the Fair Shot Coalition in support of banning the box. We believe qualified applicants who have served their time deserve a second chance, a fair chance at finding employment. Portland has an opportunity to lead this issue. We support the ordinance to ban the box, and I encourage you to pass strong ordinance that includes a conditional offer requirement and does not include the loopholes. For years, CIO members and supporters has been waiting for progress here in Portland. We were heartened to see that the state bill passed, but know that it was only first step to addressing this issue. Barriers to end living only perpetuates inequities. It challenges people and denies people to have a fair chance to move forward. Personally, I can do a parallel comparison to my own personal experience. 15 years ago, I came to this country and this great city of Portland as a refugee. My resume was as blank as this piece of paper. All I want is someone to give me a chance to work, a chance to earn a living. When I applied and got my first job at the DoubleTree Hotel Lawyer Center, you have no clue how I felt when I got that offer. It made the whole difference to me personally because I didn't know anybody. I didn't have any backup plan. I didn't know anybody in the city of Portland. I was alone by myself. And that first step, the opportunity that I was given, is all the folks here today are asking. Nobody's asking anything else. We want to give an opportunity for people. For that reason, I encourage you to ban the box. Thank you.
Thank you very much. Thank you all. Okay, let's take the next group on the list.
The last three people I show signed up are Marion Haynes, Jerry Jimenez, and James Taylor Jimenez. Sorry.
Come on up. Hey, Marianne, I think you're first.
Okay. Good evening, Mayor Hales, council members. My name is Marion Haynes, and I'm with the Portland Business Alliance. I frankly feel like I'm in a very awkward role here before you today. As we have said from the very beginning with this, when this conversation started, we support the goal of banning the box. We supported the bill in Salem to ban the box. So much so that when I was here testifying last time, I remember sitting next to Mike Alexander talking about how the Urban League and the Portland Business Alliance were in violent agreement about the goals that we were trying to accomplish here. And that's absolutely true. It's hard to disagree with a lot of what has been said about the impact that people have when they have a criminal conviction and what that history has been, how that impacts communities of colors. We don't disagree with that, and that is why we support the goal. It's why we understand the value of a job. That being said, our strong preference is to let the state bill work. We've heard a lot today about how it doesn't go far enough, and my question is, how do we know? The state bill hasn't been implemented yet. There's been no data gathered. We haven't seen whether there's a number of claims. We haven't seen whether more people are getting into jobs. That data hasn't been collected. The State Employment Department is in a position to do that. We just don't know. I think there's been a lot of good questions raised about how jobs will be determined, whether that job fits into the matrix or not, whether a particular job fits into the public safety and business necessity requirement. That will be left up to rules. You know, I know some examples of ones that could fit into those rules, but we don't know the examples of all the jobs out there. Employers are in the best position to know whether that job has a public safety or a business necessity element that a certain criminal conviction, not every criminal conviction, but a certain one may be relevant to. You know, we heard from the Law Center that Alameda County found that that wasn't a problem with them. That was for their own positions. They banned their own box, not making a judgment for other private employers. So again, I think there's been a lot of good questions raised. We strongly believe with the goal. We think that what the state has done was a good step forward, and we ought to let that work be implemented. It's only going to be another month and a half from now, and understand whether that makes the kind of progress that we all would like to see on this issue. Thank you.
Thank you. Good evening.
Good evening, Mayor Hales, commissioners. I kind of hesitated to come up, but first of all, my name is James Taylor. I've been a homeowner and resident of the city of Portland since 1981, and I've been a banker in the community since 1980. As I said, I hesitated to come up, but after hearing the testimony, and I do applaud the work that's gone into this code, and I applaud the Urban League for taking the steps that they've taken. However, I don't believe that it goes far enough. You know, when I hear that the Senate and the House had two versions, and I guess the watered one won out. And then I hear the city of Portland tackling the same issue, and I applaud you for tackling the issue, but I don't think it's gone far enough. If people that are incarcerated serve their time, they've paid their debt to society. I think we can all agree upon that. So banning the box is the correct thing, but I think it should end there. People have paid their dues. Let's ban the box. There should be no additional steps that the individual has to go through to prove their worthiness as a citizen. I understand the business community is pushing for certain concessions, and I can understand why. And that's why, you know, you guys have proposed compromises to appease the business community. But individuals have paid their debts to society. There should be no conditional letter, and then let's find out what crime you did. What's the purpose? I mean, the deputy city attorney testified earlier, and she gave the example of a pregnant woman. If a pregnant woman came into an employer where she appeared to be pregnant, the employer is prohibited by law from asking her certain questions. Now, if that employer wanted to offer her a job and tendered a conditional letter of employment, can that employer then ask her how many kids does she plan on having? How much time does she plan on spending with her kids at home? It's against the law. We have laws, we have civil rights laws, we have employment laws on the books presently to protect discrimination in the workplace. But for some reason, when it comes to people of color, whenever there are laws, there has to be conditions put upon it.
Sir, can I just correct you on one point?
Yes.
You're making a very compelling case, but currently, people who have served time and are released to society are not a protected class. And the big difference in the area that you've described are race, gender, status, marital status. Those are all protected classes. So a judgment has been made that they're protected. And so one of the challenges we and everyone else has is how do you structure a system to provide some protections for someone who hasn't been determined to be a protected class? Your point about race is important because disproportionately the people we're talking about happen to be African American.
Correct.
So there's a disparate impact. But just be clear, the difference between the pregnant woman and the person who is released from prison technically has to do with the fact that one is a protected class and the other one isn't.
Point well taken, I agree with you. My point is that if you get to the point of a conditional offer, the employer has made a decision to hire that person based on their interview and their skills. So why does there need to be a question of their background? My premise is that if the person has paid their debts to society, why can't we let it end there? That's my point. And I'm asking you to make the tough decision. It's a compromise to do what you've done, and I applaud you for doing that. But I'm asking you to make the tough decision and ban the box and let that be it.
Thank you very much. Good evening.
Good evening. My name is Jerry Jimenez. I work for the City of Portland. I'm off the clock. It's past 5 o'clock. I am a survivor of domestic violence, childhood sexual abuse, being trafficked. When I first came back to Portland in 1989, I was trafficked by a gang full of people. I got charges on me because I was with that gang full of people, even though I was locked in a room every day and only let out at night to walk up and down the street. I then got involved with someone who did some drug stuff, and I was affiliated with that even though I wasn't doing it. I was going to Portland Community College to become an alcohol and drug counselor and got a felony conviction on drugs. That has been with me for 22 years. It means that whenever I apply for a place to live, like this summer when the investment firms bought my affordable housing and kicked us out, and I had to go get a much more expensive place, wherever I go to move, I have to write a letter. What I found was interesting in that, I want to do more research, was it seems as though the inner ring of Portland, actually all of those management companies have come together and said, we're not going to take felons no matter what. And then you go out further and further. By the time you get to Gresham, felons can live out there. Luckily, I found a company in North Portland where I wanted to stay who said, we only check 7 years back, so if you haven't done anything in 7 years, you're good. But it was very disconcerting to see that folks are organized in that way because that's economic redlining. This is what we're doing, not we, the City of Portland, but the folks who work with us on this. Those are some of the issues that need to be addressed. I came to the City of Portland after going through those hard times, living in a shelter for 14 months, becoming a community organizer, a labor organizer, becoming the chair of Jobs with Justice, raising the minimum wage, which we're going to do again, yes, and working for the Environmental Justice Action Group, which defeated the expansion of the I-5 freeway through North and Northeast Portland to protect people's loans. Organizing saved and changed my life. And now I'm here at the City of Portland as the program coordinator for the Diversity and Civic Leadership Partners, which many of them were here earlier and last night. Very proud of the program, and I want to thank you so much for supporting the program. But what happened when I came here, I had 3 interviews, and I was afraid. I'm going to get through one interview, I'm going to have hope. I got to the second interview, I want to have hope, but I'm putting it in God's hands because I don't know. What if I get to the third interview and they say, what about this background check? But when I got there, my director, Amalia Alarcon-Demora, said, no, we know who you are. We know you're a great organizer. We know you know a lot of people, and that's what we want you for. What you did in the past doesn't have anything to do with that. And so that type of looking and having redemption for people is what we're talking about when we're talking about redemption. Because when I signed up for class or signed up for some place to live, I've always had to write a letter explaining that's who I was, this is who I am, and leave it in the hands of people that I don't know whether or not people are hopeful and believe in redemption. But if we don't believe in redemption and we don't believe jails reform people, then we need to stop putting so much energy into the jailing system and do something different. Thank you.
Thank
you very much.
And Jerry, how long have you now been an employee of the Office of Neighborhood Involvement?
9 years this month.
Thank you very much for your
So
service.
much. Well, that's a great note for us to end our testimony on, Jerry. Thank you. We appreciate you. So I think we have some questions for staff, and I also have some suggestions about amendments. Okay, well, what I'm going to suggest, I'm going to suggest two things about amendments. Based on what we've heard today, if my seconder will agree, I'm going to withdraw the amendment about oral notice, because I think written notice makes sense, and it's not so great a burden based on what we've heard here this evening. So I think you seconded, I'm not sure who seconded
I
it.
withdraw my second.
Okay, and then I want to recommend that we add an amendment that requires that the proposed administrative rules come back to council for review.
Second.
So if the council, if it pleases the council, what I would suggest is, because of the complexity of the multiple amendments, that we ask staff to come back with a consolidated version of those amendments at our next hearing.
That would be good. And can I make another request, Mayor?
Yes?
There was the lady who testified about the current state of federal law on background checks and the sequencing and the requirements. What got my attention, Judy, about that is that since that's already a heavily regulated area, I think the council would benefit from just getting a one-pager on what that current legal framework is, and does it or does it not help us in fashioning administrative rules?
Can I just say a little bit of what I know now? The Fair Credit Reporting Act is for financial credit. There's still a question as to whether criminal history, my understanding is it's still a question as to whether criminal history is included in this rigorous test. So I will do exactly as you asked.
If you could just give us a one-pager.
absolutely will.
If there's a legal question, you'll let us know. If there's a scheme that's already been established, that obviously, if there was a federal rule that already applied, that was a first cousin of what we're considering, we'd want to track it as much as possible so there was alignment. But I'd still be interested in knowing what the architecture of that is and to whom it applies.
Commissioner, I want to reinforce that it may be instructive, but it probably is not going to be entirely determinative, because your ordinance is going to apply to a slightly wider class of employers than Title VII does.
So Harry, I have great confidence you'll make that clear in a memo. But even if it's quote-unquote instructive, it's instructive. And I'd just like to know what those requirements are, so we understand soup to nuts what we're potentially asking someone to do.
Good point. Other requests of staff? So,
Were you intending to vote on the amendments then at the next hearing and have essentially a third reading of the thing, or were you
my
gonna vote?
my suggestion is we close the public hearing at this point, that we ask staff to enroll the amendments that we've discussed and moved and seconded, minus the one that we just withdrew and plus the one that I just added verbally. But rather than asking people to vote on a package that's that complicated without having it literally in front of us redlined, I think it would be, again, on the measure twice, cut once theory. I'd like to close the public hearing and schedule this for adoption of those amendments and second reading at the same time. I believe we can do that, right?
No, you can't amend a non-emergency ordinance within
Okay.
5 days of its passage, so you'd have to then
We
bring
can
it
adopt
back
the
and vote on the
amendments next
final
week
thing.
and have second reading the week after that. So, right, Josh, you want to help us out here? Calendar issues?
No, I'm prepared to vote on the amendments. I thought they were pretty clearly laid
Well,
out.
okay, we can vote on the amendments if you're comfortable with that. And then again, ask the council have a chance to review the ordinance as amended when it comes back for second reading.
Mayor, if the purpose of voting on the amendments now is to give us a chance at a second reading to vote on it,
Yes.
that's the option. The council can always come back in a second reading and say that we want further action on amendments.
Yeah.
But let's take a vote on the amendments, just so we have something before us.
All right, so then I'll accept a motion, or we'll take a vote on the amendments as moved and seconded, all of them. And again, with an understanding that the ordinance will come back to us with those clarified and highlighted for adoption at second reading, or if the council does not please to adopt it at the second reading, we can
So Mayor,
continue after that.
let me just be clear, because it's getting late. You've proposed a series of amendments. one you've withdrawn and one you've added as a oral amendment.
That's correct, and we also
Commissioner
have
Novick,
Commissioner
you
Novick's.
still have an amendment?
Yes, and it is also moved and seconded.
Why don't we take up Steve's? Why don't we take up your package, Mayor?
Okay.
And then let's take up the oral amendment that you just made, so
All right.
so we're clear.
That's a good idea. So my amendments are the Scrivener's error to section B, which merely changed the number 8 to the number 6. The direct ordinance amendment number 2, which changes Directive C and requires that the city attorney negotiate an intergovernmental agreement with BOLI. The change to, the addition of a Directive D, that the city attorney provide counsel with a one-year report on claims by individuals or actioned by the Attorney General,
As amended in our discussion.
as amended by our discussion, exactly. Those, and I've withdrawn the amendment about oral notice to the prospective employee. So those are my amendments. So moved.
So let's take the Hales
I don't,
package.
you had number 4 about the one-year report on claims from the Attorney General.
I got that one,
Okay.
when I just mentioned that one. So those are my original amendments.
That's right, then you're doing that.
I second and I move those.
Okay, so let's take a vote, please, on those amendments to incorporate those.
Novick,
Aye.
Fritz.
Aye.
Fish.
Aye.
Saltzman.
Aye.
Hales.
Aye. Then I also want to move that we add an amendment that will require that the proposed administrative rules be brought to council for approval.
Second.
Second, any further discussion about that one? Straightforward enough. The staff will prepare administrative rules and they'll come to the council for approval. Okay, roll call on that.
Novick,
Aye.
Fritz.
Aye.
Fish.
Aye.
Saltzman.
Aye.
Hales.
Aye. And then we have Commissioner Novick's amendment that added for offenses not involving physical harm or attempted physical harm to a person to subsection 03.
Steve, would you explain that amendment again?
What this is 2310-030E, which says that nothing in this section prevents an employer from considering an applicant's criminal history after making a conditional offer of employment, except that an employer shall not consider an arrest not leading to a conviction, convictions that have been judicially voided or expunged, or charges that have been resolved through the completion of a diversion or deferral of judgment program. And I wanted to add to that, for offenses not involving physical harm or attempted physical harm to a person. In other words, if there's a diversion of judgment program for offenses involving physical harm or attempted physical harm, then I'm suggesting that it might be possible for an employer to consider that.
Yeah, and that's fairly routine, that there'll be diversion for a drug offense or for drunk driving that doesn't involve an injury, that people are given the opportunity at plea to go through diversion instead. So your intent is that if it's that kind of criminal conviction, that would not be, that would not be worthy of consideration.
What about, sorry.
So this sounds like you're drawing a distinction between violent and nonviolent?
Yes.
And your amendment actually expands the safe harbor.
Yes, it, in effect, allows an employer to consider charges that have been resolved through completion of a diversion or deferral if the offense involved physical harm or attempted
So
physical
it
harm.
narrows the safe harbor.
Narrows the safe.
It narrows the safe harbor. Otherwise, at least in theory, you could have a diversion. I don't know if this actually happens, but you have a diversion for simple assault. You get in a bar fight, you get convicted of assault, you go through diversion, and I don't know if this actually happens or not, but theoretically, at least, that could happen. And you're saying there was physical harm involved, no deal.
It may be late here, but if by creating that qualification, you're expanding the safe harbor. I just want to be clear.
But depending on what we mean by safe harbor, I assume safe harbor means that, yes, there are some things an employer can consider.
Correct.
And
Oh,
this
safe
would,
harbor for the employer.
yeah,
Yes, the
and this,
employer.
right. And this would expand such a safe harbor.
Yes.
Then I'm prepared to vote on it.
Okay.
So I have a question.
Further questions about that?
I'd like to know, do we know what deferrals are available for people who've done physical harm?
I don't know the catalog. Judy knows some.
Right. I know, for example, driving under the influence of intoxicants is one. Beyond that, I do not know. That's one specifically called out for diversion.
So in other words, if you may have caused physical harm by your DUI,
Well, that's something that we can that we need to clarify, and whether there are others, as the mayor said, other,
And another concern I
Physical
have is
offenses.
with domestic violence, which I would assume that there are some diversion programs for, in which case the perpetrator may have specifically violence against against their domestic partner, not necessarily a danger to the public at large.
It doesn't say that. It says involving harm or attempted harm.
Well, domestic violence can be a harm or
Right.
attempted harm.
I agree. That's why it wouldn't be subject to this
That's
exception.
what, my point, and it's late, I'm not making it apparently very well, is that in that case, the harm is only directed to a partner. There is not necessarily any particular risk of harm to the general public, particularly if the person has taken anger management classes or whatever. Therefore, they should still not be allowed to consider that
I think,
deferral.
from my point of view, it's propensity for violence. I don't think we can parse this out at 5:30. I think we should vote it up or down, and if we vote it up, we're saying, if we support it, we're saying to Judy, in the regulations, we'd like to see a thoughtful treatment of this, and then we have the final say on whether you got it right or wrong.
And we can also ask the police bureau and the district attorney and some others for
I
counsel.
view
but
Steve's as a broader statement of principle, and it has to be worked out in the regs.
I'm okay with that, too. Okay, are you content to take a vote on this? Then let's do, please.
Novick,
Aye.
Fritz,
No,
Fish.
Aye.
Saltzman.
Aye.
Hales.
All right. Okay, so those are our amendments. We've covered them all. You'll bring the ordinance back to us for second reading with those amendments included and with the questions that council members opposed answered.
Is this coming back just in the regular agenda next week?
That's, yes,
It does not have a time certain.
doesn't have to have time certain. It's just on the regular agenda. Okay?
Day before Thanksgiving.
Thank you
Just-
all
just-
very much. We are recessed till tomorrow at 2 p.m.